My lord, may I be permitted to mention an interim order passed by your lordship, my lord? It is expiring on 31st March, my lord. On 1st, maybe this matter may be listed, my lord. And I'm mentioning upon notice.
Extension of it.
My lord, with your lordship kind sanction, may I be permitted to mention a matter for extension of interim order. It is expiring on 31st. Yes, your lordship.
My lord, extension of interim order, my lord. 3 analogous matter. 2 in respect of 2.
Extension of interim order.
Yes, my lord.
Upon notice.
Upon notice, my lord. 3 analogous matter, my lord. In respect of 2, their notice has been received, but in respect of another one, my lord, not received. The claim that the brief has not been allotted, but at the time of admission, he was appeared. So, my lord, 3 analogous matter kindly.
Give the numbers, let me see.
Yes, my lord.
Lordship, I'm mentioning for item number 583, your lordship.
Why are you mentioning, sir?
This is urgency, your lordship.
Not taking up mentionings now.
Yes, your lordship.
Then
My lord, may I permit to mention for non-prosecution of today's list?
upon notice to the other side.
No, my lord.
Please serve.
My lord, may I give the number, then I will serve.
No. Give the serve and give them.
I don't want any exception. Only thing, only to inform you, lordship, that unless sand mining is stopped, illegal sand mining is
Please
stopped.
wait for something. Let me shorten my list, then I can take up.
Another is, may I seek your lordship's leave? The water body is being filled up. There is a direction of civil court. Now, the defendant is not. The goons of the party in power is now filling my land. If it's delayed, it will be filled up.
There is an order of the civil court, so you have order 39 rule 2A.
No, civil court's order is the defendant. They are not, they have stopped. Now the goons of the party, they have started filling up. Ultimately, their dictation, all this was doing that. Now I can understand that. But unless this is done,
Before this court, please wait for something. Yes, call
but,
the case.
if you listen, for an extension of interim order, it will be expiring on the
Mention
30th of.
upon notice to the
Yes, your lordship. Your lordship.
the numbers.
I'm great.
Yes, call the case list, please.
For judgment item number 1.
No one for the petitioner? Anybody?
No one is
The writ petition has been dismissed.
much. Good.
I'll just read out the operative part. The petitioner not only violated clause 2.5 of the deed, but also failed to pay the penal charges claimed by the authority as stipulated in the deed for rectification/regularization of the breach. The respondent authority has acted in terms of the deed of lease and was well within its authority to terminate the lease and resume the plot in question on account of breach of contract by the petitioner. The claim of the petitioner not being legally sustainable, there is also no reason to condone the delay in filing the writ petition. The writ petition fails.
Much. I appear first. Let me see. Judgment. Probably. 13th February or March. এটা দিয়ে দিও item 1.
Shantanu?
Number 2.
Order is expiring on 30th.
Oh, this is reserved for judgment.
Reserved for
Let it be extended till delivery of judgment.
Absolutely.
delivery of.
Judgment.
Heard learned counsels for the parties. Paragraph, the interim order granted earlier is extended till delivery of judgment.
Much.
String be applied.
Last order, please.
Next.
At number 3.
No, my lord, this is for extension of the interim order.
You serve the.
Yes, that is also good. So what I'm on, my lord, is running in the list.
So this time only till the dispose of the matter, other if it goes out of the lease. Like a Mataras.
Yes, it was appearing as a hearing matter.
Yes,
Let me fix a date.
yes. It's already in the list.
Yes, yes, it's. None appears for the respondents despite service of notice. Paragraph, let the matter appear under the heading Group 1 hearing on 6th May.
6th.
Paragraph, the interim order granted earlier is extended till 31st May 2024 or until further orders, comma, whichever is read.
31st May our vacation নেই ছুটি পড়ে যাবে না তো রে
Yes, prior to that, you can ask for an extension.
as well as so may I leave my
Next.
Number 4.
But I am for the petitioner. But the petitioner is a long time mining lessee and he was unable to transport his stock, and that is why he made several representations. Firstly, that was not considered, but after
You're
that,
asking for extension of the interim
my
order
lord,
for
my lord,
a-
my lord,
Let it be
And-
extended for a limited period. Mr. Dey is appearing.
grateful, my lord.
And Mr. Shaha also.
Yes,
Limited extension.
yes. To consider now,
Her learned counsels for the parties.
Lordship, may I just, Lordship, kindly take up this matter. It's a very short matter. At any day during the second half, when the Lordship is take up a hearing matter of Group 1, Lordship, kindly place the matter. I believe it will be
It's a group
disposed.
one motion. I don't find it's not the hearing.
Motion,
It's a motion.
motion. Report for the, no, affidavit one. Report
15th April.
15th April.
Let the matter appear under the heading Group 1 motion on 15th April 2024. Paragraph, the interim order granted earlier is extended till 31st May 2024 or until
Grateful,
further
ma'am.
orders, comma, whichever is read.
Grateful, my lord.
Next.
Number 5.
May it please your leadership.
Abashaya.
May it please your leadership. I'm appearing for the petitioner. This matter has come up at my instance, Lordship, for extension of interim order.
There is a direction for filing affidavit. Matter is very urgent, my lord. Matter relates to the, my lord, the fishing harp
Have you filed?
tender option. My lord, we have filed the affidavit in opposition. to the
Opposition has
last
been
petition.
filed, Lordship. I
My
have
lord, wrongly, my lord, it has been, my lord, recorded.
as affidavit of service
It
in the
is
last.
corrected, my lord.
Oh, it's opposition.
Should have gone down as a question. My lord,
We have filed the affidavit in opposition. There is a direction for filing affidavit, but they have not as yet, my lord. filed
Lordship,
the
I am
affidavit in-
very happy that the state is
But-
making this submission is coming from the state that I have.
But it should
Lordship,
not be
I
extended, my
require
lord,
Lordship.
further, my lord, there is, my lord, it's very urgent matter, my lord.
Very
Lordship,
simple.
Here, Lordship, may kindly fix the date of hearing.
Short date.
Very short date.
1 week.
Lordship, I'll be able to file it in 1 week. Actually, the petitioners stay in a island, so it becomes very difficult to
It
communicate.
stays in the
On an island. It's an island, Lordship, where they
No,
travel
it's
from.
a Noyachar, my lord.
Noyachar is an
Noyachar
island,
is
sir.
a fishing harbor. There are so many cooperative societies.
So please
Three
do not,
officer
sir, please
calls
do
for
not
my
make
lord
this
first
submission.
time
It is
for
not.
the lease of the Jolkor. And thereafter, my lord, on their application, it has been, my lord, the tender has
We
been
will argue
cancelled
about the matter,
and
Lordship.
manual
Kindly gives
tender
me
has
a
been called on.
kindly
They
gives
have
me,
challenged that.
kindly gives me a week to file my reply and extends the interim order for
Advocate
limited period.
Taylor has crept into the order passed on 9th February 2024. In the first line of the order, affidavit of service, inverted comma, rakun, be read as affidavit in opposition. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 9th February 2024. Paragraph, let the matter, learned counsel for the petitioners seeks a week's accommodation here for apostrophe, to file the affidavit in reply. Paragraph, let the matter appear under the heading Group 1 hearing on 6th May.
Lordship, the
My lord,
interim order be extended,
Like,
Lordship.
if it is possible, my lord, some early date, my lord. If it is possible. there is all these auction process isn't stalled.
22nd April.
22nd.
22nd April. Paragraph, the interim order granted earlier is extended till 31st May 2024 or until further orders, whichever is earlier.
Grateful, madam.
Next.
Number 6.
I'm for the listener respondent.
Extension.
Extension.
No notice had been served for today's listing, Your Lordship, by the petitioner upon me at least.
I could not follow. With notice, I have mentioned this.
I was not served with any notice.
Where is the notice?
That has been the.
Mentioning notice.
Kaki notice diye sir.
See, if
But
if she denies this thing, then something different.
It was received on your behalf.
Yes.
Yes.
If
Please do
she
not make
denies,
such submissions.
it's very unfortunate that this submission has been.
I apologize, Your Lordship.
Careful before you
Your
make such
Lordship.
submissions.
Now, one more thing, my lord.
Yes, have you proceeded with the
Yes, now, my
matter?
lord, one more thing.
Your
my
Lordship, a
lord.
meeting was held.
Meeting was held and there was a joint inspection. And subsequent to that, my lord, I drew the attention of the authority that certain information they admitted that is lying with the contractor. So provided they will hand over to the authority, my lord, they will on their turn they will or contractor will submit these things in periodically. So, my lord, I like to file a supplementary affidavit and annexing these things, my lord, for the proper adjudication of the dispute.
So this is good that it has proceeded.
Yes. My lord,
Your
we
Lordship,
also
Larsen and
participated.
Toubro is the contractor. They are a renowned organization. So they need not be apprehensive. This is the copy of the minutes that was discussed
I would
in
like to
the.
put this thing on by way of affidavit, my lord, because we have bitter experience over the.
Point number 4 is the
concerned.
construction
They are also-
contract has.
This to be on record. You have to
Yes,
come back
so
with
that's why I am
an
getting.
Your Lordship, the interim order may be extended till limited time. A time may be fixed, a date may be fixed for hearing of the matter. Because the award proceedings have been, compensation award proceedings have been stopped by Your Lordship pursuant to the prayer of the petitioner. So a date may be fixed, Your Lordship, Your
Yes.
Lordship. But the entire project
the
may,
detriment of the petition.
Your Lordship.
Yes.
But the,
That
Your
I have
Lordship,
fought for self-injunction.
no.
Isn't it?
So we just want a date may be fixed
Yes, yes.
and the matter may be heard out.
It was appearing as a motion, isn't it?
Your Lordship, motion, we have not filed any affidavit, Your Lordship.
Not necessary. If you want to come back with the
Your
report, you
Lordship.
can.
Only thing I like to indicate that where is my difficulties to file my claim application. Because under the law, I can file only one application. I cannot amend subsequently. That is the whole problem.
So you will come back with a supplementary
Yes,
affidavit.
my lord, I like to.
And you want to come back with a report?
Your Lordship, we will come back with a report.
Annexing this,
Yes, Your Lordship, I've already prepared it. I'll file it within 2 days, by Monday.
on prayer of the petitioner and on prayer of the parties forum. Liberty is granted to the petitioners to file a supplementary affidavit and the respondents to submit a report in the form of an affidavit as sought. Paragraph, let the matter appear under the heading Group 1 motion on 6th May.
Your Lordship, anytime in April, it may be fixed, Your Lordship. 6th May is a long time. Lordship, anytime during
1
May.
month in between, solve the issue.
Your Lordship, this will be solved between that itself. 15 days is more than enough. Your Lordship, meantime, we'll sit again if required. No, Your Lordship, meantime,
So it's going on.
Your Lordship, meantime, we'll
They
sit
assure
again.
that this will be provided to me within 15 days. I have no problem.
Your Lordship, we can
Then
sit
there
again
can be
because the
assurance on the part
contractor
of the
may sit
respondent.
I'm led by my learned.
Already there was a joint meeting.
Where is 25th April? Yes, I've heard that.
Yes, my lord, and everything was, my lord, sorted out.
Paragraph. the
Nothing has
interim
been
order
sorted out.
Granted earlier is extended till 31st May 2024 or until further orders, whichever is earlier. Next.
Number 7.
I am for the petitioner, my lord.
I appear for the alleged contemners. My lord, the order is in the process of compliance, my lord.
My lord, kindly see the last order. my lord.
Actually, we lost in compliance of your lordship's last order.
Yes, so let him come.
I have,
Principal
I
Secretary
have
is there.
communicated this order, my lord, directly.
My lord, the principal secretary is there before your lordship, my lord, to explain his conduct, my lord. Now, he has explained his conduct. My lord, on behalf of the principal secretary. Your lordship kindly sees my lord's order is of 6th of April 2022. Lord, this was brought to the notice of the principal secretary on 14th of December 2023 by the office of the DM.
You were present in court. The order was passed in your presence.
Lord, the states councils were present. The order was passed in the presence of and it was the direction was upon the land acquisition department. Your lordship kindly sees your lordship's order. If your lordship kindly sees your lordship's order, which is appearing at page.
Yes, this is a subsequent direction upon the principal secretary.
Principal secretary. My lord, this is a subsequent direction. The respondent number 9 is the land acquisition, special officer land acquisition.
24th January 2024, the principal secretary was directed.
Thereafter, my lord, immediately the principal secretary, my lord, I have explained my conduct, my lord. Immediately after getting this letter, I have received concurrence from the finance department. Your lordship kindly turns to page 3 of my affidavit.
Yes.
Paragraph 4 onwards, that for requirement of fund for direct purchase of land, the government irrigation and waterways department has moved before the finance department and concurrence has been obtained by INW department on 14th March from the finance department. My lord, thereafter, my lord, this is to be sent to the standing committee of the industry and employment and infrastructure before placing the fund to the land purchase committee concerned, and it has been sent to the standing committee. The only difficulty, my lord, today, lordship kindly sees that paragraph, my lord. My lord, the only difficulty today, my lord, the standing committee of the cabinet, which is to sit, my lord, because of the model code of conduct, they are not able to sit. So that is the only difficulty, because the process for purchase of
Code of conduct doesn't prevent any
My lord,
committee to
lord,
comply with a court order.
irrigation waterways department, my lord, whatever we was done, we were required to take approve, send it to the land department, we send it to the land department. Thereafter, it was required to be sent it to the finance department, we got the approval of the finance department. My lord, now lastly, it has to go before the standing committee of the cabinet, my lord. From there, the approval has to come, and immediately from there, my lord, the finance approval will come and the money will be disbursed. Now, the special land acquisition officer ought to have brought this to the knowledge of your lordship when the order was passed in the rate court, that if we are going for direct purchase of the land, and then this has to happen. What happened, my lord, if your lordship kindly sees the letter of the special land acquisition department, which is at page 10.
Is all this very relevant at this stage, Mr.
My lord, because I am, my lord, today, my lord, I am the principal secretary is there before lordship of the irrigation and waterways department. This letter of page 10 at page 14 December 2023. This is an elaborate letter. If your lordship kindly sees the last line of that letter, the state filed appeal. Before that, they did not intimate this department. The appeal was dismissed. When the appeal got dismissed, thereafter, my lord, this was intimated to the irrigation waterways department on December 2023.
It's also long back, isn't it?
Long back. Well, December.
Saying
My lord,
all this is not relevant at all today.
my lord, my lord. Lord, your lordship may kindly grant us some time, my lord. We are in the process of compliance, my lord, because, my lord.
And please do not take refuge to that model code of conduct.
We are not, my lord.
Not stop you from complying with the order of the court.
No, my lord. We have sent it to the, my lord, standing committee. That is the last step, my lord. Once the approval comes from the standing committee, the finance, my lord, will flow from the department, will give it to the petitioner.
How much time are you asking for?
My lord, we are asking, my lord, till 6th of June, my lord.
No, this has nothing to do with the election or model code of conduct. I must be very clear on this. You are only complying with an order of the court to avoid contempt. This is a contempt application.
No, because my lord, the land acquisition department came up before your lordship and submitted because this land has been utilized by the irrigation waterways department, so they have to give the fund. And
I will not hear any of these stories today.
Well, no, your lordship's direction was upon the land acquisition department. Lordship kindly grants
There
us.
was a further direction of the principal secretary.
Yeah, he's taking steps, my lord. Lordship may kindly, my lord, because I want to see that your lordship's order is
has been.
Steps doesn't mean you come to court each day and take
No, no,
time
my lord,
on
we
some
do not,
plea
we
or
do
the
not,
other.
we do not, my lord, we do not. Your lordship may kindly.
I'll give you 1 month's time. Otherwise, all your officials go to jail.
My lord, a bit longer time, my lord, if your lordship, my lord.
No, no, no further.
Cabinet will not hold its.
You have to give it from our pocket. You have to do something.
You will face serious consequences. Let me assure you today. If it is not complied with by the next date, there is a limit to everything.
Shall I say something, my lord? My lord, I will.
Is your advocate stepping down?
Ah.
Are you being released from the brief?
No. Please, Amaka, please. Lord,
The Principal Secretary, Irrigation and Waterways Department, Government of West Bengal is present in court. Paragraph affidavit submitted on behalf of the Principal Secretary is taken on record. Paragraph. It is most unfortunate that the order of this court has not yet been complied with by the authority. Stop. Paragraph is submitted on behalf of the Principal Secretary that
wait, one more. তনয়কে বলে ওখানে দাঁড়াতে তনয়কে বলে ওখানে দাঁড়াতে
that the matter has been placed before the standing committee
on industry infrastructure.
Standing Committee on Industry, Infrastructure and Employment, seeking approval for placing the necessary fund before the Land Purchase Committee concerned. And fund will be released in favor of the Land Purchase Committee upon receipt of such approval. Paragraph in view of the above, let the matter appear under the same heading for compliance of the order under contempt in its entirety on May 6th. Personal appearance of the Principal Secretary is dispensed with for the time being. Affidavit of compliance be submitted on the adjourned date. Next.
Item number 8, my lord.
I am for that.
My senior Vishuru Biswas has not come.
Yes.
I am for the petitioner applicant.
I am for the alleged contempt, my
No,
lord.
only not today, my lord. As today.
The solemn order has been carried in appeal, my lord. The appeal is Honorable Civil Division major session over the matter, my lord. And the thing is this, my lord, we have concluded our argument with regard to the Section 5 application, my lord, but they are yet to reply, my lord. That has not been done, my lord. Well, kindly peruse the order, my lord.
Section 5.
Well, Section 5. Well, kindly peruse the order, my lord. My lord.
But that was not allowed. No stay also, my lord.
There is no stay. I am not saying that there is stay, my lord.
This is the connected judgment which is
My lord,
which has
my
been
lord,
added in the
my lord.
This,
We have concluded our argument, my lord. Thereafter, the regular bench was not available due to that, my lord.
Another order.
They have challenged the division based, my lord, mother order, 2015, my lord, Justice
Yes, but
Alpha.
the order under contempt
Subsequently,
relies upon that order, isn't it?
Yes, yes.
So if the mother order goes, what is the consequence? What happens to the subsequent?
they have also filed here, my lord, recalling application. My lord's order.
But that has been filed, but
And,
your lordship was of the
and
view.
appeal-
Decided when the appeal is decided, isn't
Yes.
it?
Well,
Out of list for the time being, liberty to mention.
as your lordship.
In view of the fact that, in view of the observation made in the order passed on 13th February 2024, comma, let the matter go out of list. Stop, liberty to mention.
Yes.
Next.
এদিকে এসো বাবু।
পরেরটা এদিকে চলে আসতে হবে। 9 ও পিটিশনার বা 10 এর রেসপন্ডেন্ট।
ঠিক আছে আর নয়
Well, on 28th of February, your lordship directed to demarcate the plot of the
Yes, my lord, I have got the report, my lord. It has been demarcated in presence of all the parties.
For the alleged contempt amendment. এই ললিত একটা রিপোর্ট দেন আমাকে।
দিয়ে দাও, একটা দিয়ে দাও।
দিচ্ছি।
Have you received the report?
My lord, just now.
You want to go through this and come back?
My lord. Well, let them place what. Well, yes, my lord. Only, my lord, 0.82 acre of land is acquired, my lord.
No, that is not the correct. Acquired land is, my lord, 2.802 in plot number 2269 and 2303. That is the correct plot number. That is 2.9834 acres have been acquired. And
Acquired area of NHAI falling in the leasehold area in plot number 2269, 2303 are 0.00 acre and 0.82 acre respectively. Well, page 2.
page one. Kindly see the page one.
Total area yes, total area acquisition of
Yes.
2269 and 2303 is a big plot. Partly is mine.
Or file an exception? No.
No, exception is not at all
Not necessary.
required, man. Not as necessary because 2269 and 2303 is a big plot. It is acquired 2.081
And, my lord, that
2.983.
and
Out
two,
of
my lord,
which
one correction is also necessary. That is 2603, which was my lord's order. That would be 2303.
that has already been
And
done.
my lord, the rest of the part, my lord, should be complied with.
Yes, my lord. So page 2, your lordship will find that the acquired area in my plot, my area is only 0.82 acre. So rest of the land is mine. Let them issue the challan in respect of that. 2269 is a big plot. Entire plot is, but my area is falling only 0.82 acre.
No.
লেফট পার্ট কতটা? লেফট আউট পার্ট
সেটা তো দেয়নি।
লেফট আউট পার্ট কতটা?
Left out, yes, it is given, it is
Total area
think it
20
would be
point,
better
total area, my lord, 20 acre.
I think
Yes,
it would be
yes,
better
yes.
if you go through this and come back with your
My lord.
submissions. Since I'll dispose
My
of
lord.
the review application on the basis of.
Yes, my lord, yes. It is on the basis of review application, your lordship directed to sketch the,
Yes.
demarcate my area.
And my lord, the map has been already given, demarcating the,
You have given it
My
to him
lord.
itself.
my lord.
So he
My
needs
lord.
after,
My lord.
please
Yes.
find the, check the map also.
My lord, my lord. Yes, my lord, it is a clear, man. This is my leasehold area. Acquired area is simply this, only this portion.
লেফট আউট পার্ট কোথা সেটুকুনি বলে দাও না, তুমি দর্শকের এক্সেপশন দিলে দিয়ে দেবে।
Left out part konta. 2269 is a big plot. Only, my lord, this is the, this area, my lord, this is the bridge is going over there. My lord, kindly.
এইটুকুনি পাবি, এবারে এখান থেকে
এখান,
দুশো
my
মিটার
lord,
ছেড়ে দিবি।
my lord, only the corner portion,
Corner portion.
Yes,
corner
yes.
portion, that is the acquired portion,
That
and
is
but
utilized, and yes.
corner portion, and my lord, as the bridge will be, my lord, constructed, some portions will,
200 meters, মানে this portionটা will be left over, তাই তো?
yes,
এই
left
portionটা।
over.
হ্যাঁ
Only in this corner portion, the rest of the
Rest
portion.
of the
will-
portion,
you will get.
yes, yes, and after 200 meters, he will entitle.
This is
Yes.
leaving this corner portion.
Yes, yes.
Rest of the part. you
Rest
will
of
get.
the part, মানে rest of the part and two.
এইটাই
eh,
200
eh,
মিটার বাকি
Yes.
হ্যাঁ
The- the-
হ্যাঁ
বলে দেবে, ওটা বলে দেবে।
সেটা তো
তুই ওটা
ওখানে
বল।
ডিএলআরও সবাই আছেন
Section দিয়ে
ওনারা
পড়ে নাও না।
করে নিলেও তো হয় আপনারা বলে দিন না যে
না, না, তুমি একবার এখানে পড়ে
তাহলেই তো হয়ে গেল
Next date, next.
চালান তো
আমি তো contempt এ বলছি।
My lord, kindly give me 1 week time, my lord. Otherwise, my lord, I am suffering from November 2022, my lord. Yes,
So that both can be disposed of.
yes, I want, my lord, also because of the due to pendency of this, my lord, I am suffering not getting the challan.
তো যদি এটা
That
হয়ে
is-
থাকে contempt দুটো একসঙ্গে dispose of করি।
হ্যাঁ, দুটো একসঙ্গেই হয়ে যায়।
Yes, yes, yes.
যদি বললাম ওকে দেখে নিয়ে তুই ল্যান্ডটা বল কতটুকু তুই পাবি ওই 200 মিটার
Kindly,
সেইটুকু
হ্যাঁ।
এরিয়া
আমরাই বা কি করে বলবো ওটা তো আপনাদের অথরিটি বলে দেওয়া উচিত সেই তো ঠিক
নেক্সট ডে তে দুটো একসঙ্গে dispose of করিয়ে না।
বল ডিএলআর
compliance report দেবো।
কি চাইলে এসে কথা বলে দেখুন
এই রোরি, আমি আর compliance
So
report
now that the demarcation is very clear,
Yes.
the only option left for the authority is to issue challans in
Yes.
respect of the remaining.
for the rest of
Yes,
the area.
rest of
which
the
are-
Rest of the area and, my lord, 200 meters, as the proposed beach, the acquisition has been for proposed beach. So 200 meter, leaving out that other portion would be, my lord, given to the petition.
I'll give you some time for compliance.
My lord,
Please comply with the order under contempt and come back,
my lord, my lord,
My lord,
so that both can be disposed of.
my
my
lord,
lord.
my lord.
আজকে বর্তমান
আজকে 28
Demarcation report submitted by the district land and land reforms
দাদা
officer
এটা তুমি বলো 15 থেকে
and additional district magistrate
15 না,
Common
এখন
Bankura
election আছে।
is taken on record.
পরে election আছে, আমি
Election
ব্যস্ত
আছে
হয়ে
তো?
যাবো। ভালো বুঝিস না।
It appears from the
Election আছে,
report
that
the total
আরে
area acquired by the NHI
এবং
in
OTT election গুলো আগে হয়েছে।
NHI is plot now
সেটা বল
is
সেটা বল আবার নাহলে ফালতু
NHI
দেরি
in
হয়ে যাবে।
plot number
দেরি করে নিস।
269 is 2.0801 acres and in plot number 2303 না এটা উল্টো করুন NHI is 2.0801 acres in plot number 2269 and 2.9834 acres 2.9834 acres in plot number 2303.
এই টাইমটা বেশি নিয়ে নেই রোরি।
Paragraph. Learned counsel for the applicant petitioner seeks to peruse the report. Stop. Learned counsels for the alleged contemners seek accommodation to comply with the order
My
under
lord.
contempt. Paragraph. Let the matter appear under the same heading on 18th April.
My lord, some more time because the election period, all the DMT and officers are involved, my lord.
That is not at all
All is-
relevant, my lord.
Has to be-
Challan issue, challan will be issued by the
All the
WPMBTCL, my
all
lord.
the
They
officers, they are involved in the election process.
My lord, that
Election
cannot,
process.
my lord, court order cannot be, my lord, stopped
And
due
it is
to.
not, it is not
My-
that we are defying
Sir,
the
ঠিক
court
আছে।
order.
My
but
lord, I am
time is
suffering
required
from
because
1 and
the
5
DM
years.
other officers are-
25th April.
My lord.
25th April, my lord. My lord, on that day, my lord, let them issue the challan in the meantime.
Compliance.
Compliance, my lord. স্যার হ্যাঁ চালানটা ইস্যু করতে বলুন
Next.
কপাল ফাটালেন কেন? আপনিও কীর্তি দিয়ে মতো আপনাকে
আজকে please, please, sir.
কার ঘরে?
Well, I tell you, Lord,
File.
my lord, file has been, my lord,
Yes, before the
fixed,
election.
kindly adjourn for 2 weeks because today the matter has been fixed.
I cannot pass an order. The file itself
Yes.
is not. When is the date fixed, Mr. Khan? Is it the division?
Today. Yes, matter is going on, already heard out, and one report is required. So that's why the file has been.
Next.
I am for the petition in this matter. Pursuant to your lordship direction, the contempt petition was served and that was not delivered. My lord, your lordship's order on 4th of October 2023, after dismissal of my lord 10 for application of appeal filed by one of the writ petition in this matter. My lord, your lordship was, my lord, after dismissal of the appeal, they challenged the writ petition, and my lord, the and the my lord the and my lord the your lordship was directed my lord to they file an application to section 8 application. Your lordship was directed to consider the section 8 application, and if it is negative, kindly come to your lordship's order and page 3 my lord, and then last page my lord, kindly come to page 4. If the application filed by the petitioner is decided in negative, necessary steps to be taken by the authority under section 10 of the act for demolition of the unconstitutional fourth week. My lord, the authority decided the issue on 10th of November 2023. My lord, till date,
No further steps.
no further steps was taken.
My lord, one Yusuf Sheikh moved a writ petition, being WP number 23844 2023.
I am the private respondent in this writ
ওকে
petition.
বলতে দাও, তুমি তো বলনি। Petitioner, my applicant herein, my lord, he was the private respondent to that. My lord was pleased to pass an order, which my learned friend my just did, to dispose of the application under section 8. That has been disposed of. It is negative, my lord. Rejected the
The
application.
contempt application is filed by the private respondent.
Private
to the
respondent.
petition.
Yes.
Have you served the petitioner?
Well, I am my lord with regard to the list part, my lord, because my on the basis of my application the process was initiated. Now section 8 application filed by the writ petition, your lordship was directed. If it is negated, the authority will take step for demolition. They resist the proceeding, my lord, by filing the writ petition.
Can the private respondent file a contempt application?
Because the authority did not take any steps on the basis of your order. Well, I am the party in the writ proceeding. It is not that I am not the party in the proceeding.
Have you served the petitioner?
Because I have no allegation against the petitioner, because my lord, I have the contempt against the person who has been not complied with the order.
Yes, Mr. Bandapade.
Pursuant to your lordship's direction, my lord, the step has been taken. The removal program was fixed on my lord first on 16th.
Section 10 has been initiated.
Section 10 was initiated, 10-3, 10-4. Appeal was filed.
No, no, after 10-4,
After 10-4, you will also file a settlement. That was negated.
First, my lord, that on 16th of February, my lord, তোমাকে এখন দেবো না, তোমাকে দেবো কেন? On 16th of February, my lord, the program was scheduled. My lord, this is my lord, the report, my lord, it has not been signed. It is not the fair document. It is
so you
not
have to
signed.
come back with a compliance
lord.
report.
On 16th of February, my lord, the program was rescheduled. But on that, my lord, it was not possible due to the, my lord, the inadequate police assistance. Police authority said, my lord, your lordship, kindly turn to page 10. Due to higher secondary, last paragraph, secondary examination, a large number of policemen will engage, such and such. Therefore, they were requested to reschedule. Accordingly, my lord, rescheduled program was, my lord, settled on 22nd March. The police authority, my lord, along with the one magistrate, my lord, went to the spot, but the petitioners and along with the public, my lord, resisted. Your lordship, kindly turn over the pictures. And thereafter, and my lord, again, we have, my lord, time is taken, my lord. Force, my lord, for reschedulement, for the removal of the encroachment.
The
It
police-
requires some time, my lord.
The police has requested them to leave. It is not the job of the police.
My lord, your lordship, kindly,
Police is deployed only when there is resistance.
my lord, your removal of encroachment, subdivisional magistrate Diamond Harbour. Approach the subject matter such and such. This is to inform as per your data such and such. The executive magistrate and block development officer Mograhat 12. Tuhin Subro Mohanty, assistant engineer Lokhikantapur Higher Subdivision, PLLRO Mograhat 2. Officer in charge Mograhat Police Station was present on the spot. Removal of encroachment with required machinery and police force. After our arrival at the spot, the said encroacher along with the police, local people started agitation and they will not allow us to for removal.
Isn't that quite natural?
My lord, therefore, my
They
lord,
will not say, come and
it
please
was not
demolish
possible
my-
on that day,
my
my lord.
structure.
We are, my lord, the rescheduled, my lord, any another date, my lord. Yesterday, talked with the, my lord, the SDP is requested to, my lord,
I'll
for
give you 2 weeks.
more police picketing.
I'll give you 2 weeks more.
I shall try, my lord.
Please carry out the
My
order.
lord. It will be
Fine,
carried,
please.
my lord's order will be carried on.
Please do that.
But the petitioner, my lord, read petitioner himself, my lord, registered.
Yes, because he is the encroacher.
He is the encroacher.
He is the encroacher. He had
Encroacher.
come before this court
Yes,
under
my
the
lord.
entry order.
Yes, my lord.
So he
My lord's order will be carried out, my lord, with the adequate force. My lord, we have requested the
is
SDPO.
also not
But
expected that
some time be given, my lord, we shall carry out. My lord, we are bound to mal carry out your lordship's order.
affidavit of service. The paragraph is submitted on
My
behalf
lord,
of
we
the.
shall take back, my lord, on the next.
Yes, we come back on an affidavit.
My lord, we shall complete.
Definitely. It is submitted on behalf of the alleged contemners. That
My lord, one thing, my lord, in my application, there is no name of the contemner number 2. Contemner, no, 1, not 2. What Joseph আছে কিনা আমি জানি না। It is blank, Mr. Blank.
First one, Tapas Bhattacharya, and second one, my lord, I have been mentioned.
Second is Mr. Blank. Page 6 of the application.
Contempt
Contempt
application.
তার নাম দাওনি কেন? নামগুলো দেবে
নাম
তো?
দিয়েছি, ওখানে দিয়েছি আমারটাতে
এক্সিকিউটিভ
এক্সিকিউটিভ ইঞ্জিনিয়ার পেজ 6
জসেরটা আছে কিনা আমি জানি না। আমাদেরটাই নেই।
জসের মধ্যে ফাইল হবে না।
হবে না না সবই হবে।
रोड का है यार मिशन एडवोकेट का है चार बजे आएगा लेकिन किधर है ये तो मुझे देखा है
it is written by hand.
And that was my mistake.
Joyanto Pal.
Joyanto Pal.
Mr. Joyanto Pal.
That was in handwriting.
My lord, your lordship, kindly allow me some time. We shall carry out. We shall obey your lordship.
The
Joyanto Pal.
alleged contemners are taking necessary steps for compliance of the order under contempt. Paragraph. Let the matter appear under the same heading on 18th April.
My lord.
Paragraph affidavit of compliance be submitted on the adjournment. Applicants apply private resort. Next, Khali applicant. Next one.
In this matter, my lord, the lordship heard the matter on 6th of March and directed me the office manager accordingly. I sent the notice. My lord, one Mr. Orkona was appearing in the matter. He is not in the panel at present. And Mr. Srishanlo Bandyopadhyay, who is the senior, he asked my clerk to serve the advocate on the court. But Orkona is not appearing in the panel at present.
You need to serve the GP's office. That is sufficient.
My lord,
You don't need to serve anyone individually.
my lord, GP officer asked my clerk to serve the copy to the particular advocate, my lord. I searched him, my lord, I came to know that Mr. Orkona was appearing. After searching, I came to know that he is not in the panel, my lord.
What kind of?
My
It
lord,
was dismissed for
overcome the-
default.
My lord,
It will be a fresh appointment.
my lord,
It was dismissed for default, isn't
yes,
it?
my lord,
Then restored. So it will be a fresh appointment.
Hello?
It will be a fresh appointment of the state advocate. You don't need to serve on the earlier advocate.
and that is why, my lord, in the earlier version, I served all the legislators for the peace, my lord, to overcome the application, along with the restoration application and other main petition, my lord. In the office, my lord, on the other day, that is 6th of March, I have submitted the affidavit of service, my lord, and see the respondent's office, my lord, each and every respondent's office, I have served.
Please serve the GP's office and come back.
Hello?
Please serve the GP's office, nowhere else.
But GP office is saying, keep the particular advocate, my lord. Certain I came to know, Orkona is not present again.
Not necessary at all.
They are not accepting, my lord. That is the problem. And to overcome this situation,
Please inform them this is the court's direction to serve on the GP's office. I'll record it in my order. I'll record it in my order.
my lord,
You only have to serve the GP's office. You don't have to look for the advocate.
yeah. হ্যাঁ হ্যাঁ আমি অফিসেও পাঠিয়ে দিয়েছি। এই তো দেখুন আমি নোটিশ পাঠিয়েছি, নাই না?
Service upon the state respondents is yet to be made. Paragraph, the petitioner is directed to serve a copy of the writ petition along with annexure thereto at the office of the learned government pleader and file affidavit of service on the adjourned date. At the office of the government pleader. Paragraph, let the matter appear under the same heading on
Original petition and
copy of the writ petition along with annexure. I've recorded that. I've recorded that. Yes, yes. Investigation is over.
Copy of the lease petition I also sent, my lord.
अरे xerox copy दीजिए जरा।
Just for the other.
Now the GP's office, I'm giving you instructions. To look for advocates. Because this will be a fresh appointment. Since the matter was restored after dismissal, it will be a fresh appointment. You have to serve the notices afresh. Let the matter appear under the same heading on 17th April.
17th April. Yes, my lord.
Sir, wait. Notice of
14 minor, I am appearing for the state as led by Mr. Soumitra Bandyopadhyay. Well, I appear on behalf of the. Well, this is a affidavit of service. Well, the petitioner lodged a complaint before the authority concerned alleging that the private respondent has made a
Service.
loss. I have served. Already served. Well, they have received. So only, my lord, I am saying the authority concerned has already taken step by demarcating the plot in question. So now the proceeding has not been completed. So, my lord, I am seeking direction upon the authority concerned by taking into consideration my representation, my lord, on 15th, my lord, kindly come to page 15.
This is under the 62 Act.
The SDO is the competent authority, Lord says no. So, my lord, this will let them to complete the proceeding after giving an opportunity of hearing upon the parties. And so, my lord, this, so I have been informed. With representation. Page 15.
Where is your representation?
Page 15.
Yes.
Yes, madam.
Let that be done.
Yes, let the application be discussed.
Since demarcation has been made already.
So complete the proceeding after giving an opportunity of hearing. Let's get.
Affidavit of service. None appears for the private respondent despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of government land adjoining her plot, thereby obstructing her egress and ingress. The petitioner submitted a representation before the concerned authority in this regard on 2nd February 2021, pursuant to which demarcation of the plot in dispute has been made by the Block Land and Land Reforms Officer. Roman 1. Stop. The petitioner prays for consideration of her representation and initiation of proceedings under the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act 1962. Paragraph, learned counsel for the state respondents submits that the third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing, to the interest to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. Paragraph, since demarcation of the plot in dispute has been held, comma, in the event encroachment upon government land or any portion thereof is found, comma, the third respondent be directed to initiate proceedings under the Act of 1962 and take the proceedings to its logical conclusion within 2 months from the date of communication of this order.
Get into loss. Get.
Order in accordance with law.
Malad, the affidavit of service.
Take.
Get.
Dispose of. Next.
Calculator. 18.
May I file my reply, sir? The supplementary affidavit filed by the respondent number 2 and 4. But, finally, Mr. Date will not for hearing.
Sir, date. Have you received copy of?
Yes, I have. We have received.
He's asking for time. Let me.
My lord, may fix a date, my lord. It will take some time. This hearing will take some time.
Voluminous pleadings, sir.
It may be also fixed under the category hearing heading, my lord, subject to my lord's sanction.
Rejoinder submitted by the petitioners. The supplementary affidavit filed by respondent numbers 2 and 4 is taken on record. Paragraph, on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd May.
Second. For the same 18.
Next.
Lordship, I beg to appear for the petition, Your Lordship. I am led by Mr. Partho Pratim Roy, Your Lordship. Your Lordship, on the last occasion, Your Lordship.
Appearing for the respondents. Yesterday, yes. And WBSCDCL, Mr. Paja is appearing. Where is he?
আপনি Your Lordship, on the last occasion, Your Lordship, the WBSCDCL has filed the report in the form of affidavit, Your Lordship. But till date, I have not
Lordship,
received any affidavit, Your Lordship.
Lordship, Mr. Paja out of station, so kindly not this week.
Mr. Day, your report. Taken several extensions for it.
I know it, I try to
Learned Counsel for the state respondents seeks further extension of time to submit report in the form of affidavit as sought. Mr. Day, last chance. As a last chance, the prayer is allowed.
Last chance.
Paragraph. On prayer of the petitioner, on prayer of the WBSCDCL, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th April.
Deeply obliged, Your Lordship.
At a petitioner copy. সোমবারে ওই জানা তিন জিনিসটা হচ্ছে
My lord, I am for the petitioner.
Yes, 70.
Now, right now.
My lord, the case is that the private respondents changing the nature and character of their land, modified their land from Jol to battlefield. And for that, my land is, my paddy land has been totally devastated. And I am not, I am cultivating there. But for that reason, I can't cultivate it there because of.
It is a private dispute. Dispute between two private individuals. No government authority or government land is involved.
No, my
How
lord.
is the writ petition maintainable? Yes. I have to dismiss it on this ground. There is no public element. And if it is conversion, it comes under the Land Reforms Act 4C. You have to apply before the
My lord,
authority.
my lord.
So why have you filed this writ petition?
My lord,
To take a chance before this.
my lord, I want to withdraw it and kindly give me liberty to file it.
Right, absolutely. That is a good idea.
My lord.
Affidavit of service. The petitioners seek to withdraw the writ petition and take appropriate steps and take necessary steps before the appropriate forum. Paragraph in view of the above, the writ petition being WPA such as dismissal non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Paragraph, there shall however be no redress to costs as in certified website.
Fine.
Next.
I have for the this one 5 and 6.
Petitioner?
Malad, I'm for the state. I'm led by kindly see the last order. 18 January. Last order. No.
Second page.
Yes, has the district judge sent the necessary statements? What is the
What I have come from,
now?
I have come to know from my learned friend that we have sent it to the judicial secretary. But
That was the direction. That was the direction.
But judicial secretary has sent nothing to our office. That's on 5 and 6. The unfortunate specification was there in the last August.
একজন হয়ে গেছে আধা গাদা নিয়েও গেছে
কপিগুলো গেছে গেছে ওই সে পাঁজা আছে
Yes, it has been sent to the judicial secretary, Mr. Mondal. Then after that, take the microphone, please.
All relevant documents already sent to the judicial secretary.
You are representing the judicial secretary also.
Lordship.
So what has the judicial secretary done? It
At
has to go
present,
to the fifth respondent.
Lordship, it will take time, my lord, for information. That copy already sent to the AG.
এখনো যায়নি
এখনো যায়নি।
Till nothing has reached to our.
This was sent on 26th February 2024. We are at the end of March 2024. What has happened in between?
7th March also.
7 March.
Another
Yes. So we are at the end of March.
তো আমরা দেখি খবর নেবো তাহলে
1 week time, my lord, for
1 week না 2 weeks
detailed information.
2 weeks time.
There is no any I hope that there is no any problem.
Judicial secretary will verify the same and send it to the fifth respondent. That's all. For disbursement. Why is it taking so much time?
So kindly grant 7 days time, my lord.
7 days it will be sent to the fifth respondent within 7 days. Submitted on behalf of the state respondents that in terms of the order passed by this court on January 18, 2024, the learned district judge has sent
একটু কাগজ
fresh applications along with skeleton statements in respect of the total award money of rupees total award money in favor of rupees in favor of all the petitioners to the Principal Secretary, Judicial Department, Government of West Bengal. Stop. It is not understood why the order dated January 18, 2024 has not been complied with by the Principal Secretary as yet. Paragraph learned counsel for the state respondents seek a week's accommodation for the Principal Secretary, Judicial Department to comply with the order and send the applications as well as skeleton statements applications along with the skeleton statements to the fifth respondent upon verification of the same.
Another certificate is required. Since they are saying sending the skeleton report, madam. That's why certificate is required that this payment has not been made earlier.
Now, upon verification of the same,
The certificate is necessary.
who will issue the certificate?
Admittedly, no payment has been made.
Yes.
Admittedly, no payment has been
No, no, no.
Formality will not need to save some more time.
Let them verify and come. Send it to you. Paragraph, let the matter appear under the same heading
another fine
on
admitted. তাহলে মোটামুটি
8th April.
8 April.
আর তার আগে একদম শুরুতে করুন যে letters issued by the learned district judge, Paschim Medinipur, to the Principal Secretary, Judicial Department, Government of West Bengal, along with relevant documents, submitted by the state respondents are taken on. Next.
19, I am for the petitioner, madam. And the advocate on record could not come to the court today, my lord, due to some family emergency, my lord.
You're asking for an
I
adjournment?
pray for an ad, not today, my lord.
On prayer of the petitioner, petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th April. 29th.
29th April.
Yes.
For railway.
Petitioner is asking for an adjournment. Next.
In this matter, I am for the petitioner that there is some change of circumstance, my lord. I want to bring it on record by your supplementary affidavit. If your lordship wants me to leave,
The respondents.
my lord, first time it's appearing. Lordship, may I take your lordship 2 minutes time, or if your lordship grant me leave that, my lord, and if your lordship so desires,
Mr. Shaha is appearing for the MDDC.
whether they are party or not, because there is an order passed by district authority and the appeal, my lord, has been assailed here. So, my lord, I do not know whether they have been made party or not. My lord, let me ascertain, my lord.
No, they are not party.
No, they are not party
Yes,
because,
yes,
my lord, in this matter, my lord, the refund was paid for. That was turned down by district magistrate, district authority. That has been assailed in the appeal. Appeal also dismissed. Against that, I have come up. So, my lord, MDCL has no role to play here, my lord. So that they have not been made party. My lord, now what the petitioner wants, he wants the LTML to be executed. He wanted the refund earlier because no sand was there. Now it has been found, the replenishment was there, the sand is found there, my lord, they want to extract the sand.
I did not find service upon the state.
My lord, the affidavit of service is here, my lord. I may be excused, my lord, that is all.
So it is served. I do not find anyone appearing.
My lord.
Why don't you come back with the
Fortnight,
supplementary affidavit?
Fortnight, my
If no one still appears for the state, I'll request someone to.
lord. After a fortnight, I will come.
Affidavit of service filed on behalf of the petitioner is taken on record. Paragraph, none appears for the respondents despite service. Paragraph, on prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, let the matter appear under the same heading on 24th April.
I'm led by Mr. Mukherjee, Mr. Probal Mukherjee. May I give his name?
What there in court? Next.
Number the state respondent in this.
Lord, I appear on behalf of private respondent number 5. My lord, on the last occasion also the petitioner was not present.
My lord, I'm for the petitioner, my lord.
Yes.
Affidavit of service, dear my lord. My lord, may I place my case, my lord? My lord, the grievance of the private respondent is that, my lord, I have made an unauthorized construction over the property belongs to the West Bengal Highway Authority, my lord. And my lord, my lord, made a complaint before the executive magistrate, my lord. Upon his complaint, my lord, I have been served a notice, my lord. That is, my lord, on the page, my lord, annexer P5, my lord, page 23, my lord. My lord, this is my innocuous peer, my lord, before your lordship, my lord. This cannot be done, my lord. This executive, my lord, the assistant engineer to file the serve this notice upon me on the basis of the separate complaint, my lord. Because, my lord, as per the section 10 of the West Bengal Highway Acts, my lord.
Page 19 is the note.
Page 23, my lord.
Page 23.
This has been issued in terms of.
My lord, it is not served in terms of the law, in accordance with the law, my lord. My lord, I have innocuous peer before your lordship to direct the authority concerned to give me a notice in accordance with law and kindly frame a time so that the proceedings can be done in accordance with law.
This notice has been given for eviction. What law you want?
My lord, the section 10 of the West Bengal Highway Act is not saying so, my lord.
We have got.
Where is the section 10 notice?
Yes, it is there. This is the page 5. Page 5, you can see that.
Page 5.
Page 5, page 23.
And it's a P5.
My lord, it is not section 10 notice, my lord. Kindly see, my lord. No provision is.
That this letter is final 7 days. It's final. You are unauthorized structure from the government.
Where is no provisions is mentioned here, but over here. I'm sorry.
My lord, may I just hand over the
particular act is of the time.
put in it.
Yes, you're referring to section 10.
No, I am referring to, Miller, kindly see section 10, then section 11. Now, Miller, it seems, Miller, subject to correction of my lords, that the action under section 10 that my lords will be pleased to find at page 21 of the writ petition. When the authorities proceed, they had, Miller, indicated about
So has the section 10 proceeding been completed?
No.
Miller, I do not appear.
Notice.
This is the 10-1 notice.
This is the 10-1 notice has been.
Is
So
this
he
the
has
form
been
of
given
No, my lord.
on time
This
to
cannot be.
get himself evicted from the unauthorized construction. So he is not doing that. Instead of getting himself evicted, he has come before your lordship.
If he doesn't get himself evicted, what is the next course of action?
Then we will go according to the procedure. We will go under section 10-2 and 10-3?
So has that been done?
No, my
Millard, I submit to my lord your,
The notice is not in terms of 10-1.
Millard, kindly see, Millard, no, yeah, it's fine, Millard, subject to correction, page 21. Kindly see page 21 of the writ petition. Page 21 of the writ petition, that within the provisions of the West Bengal Highways Act 1964, second paragraph, clause 10(1)(b), it is identified that your unauthorized structure is an encroachment on the said plot of land. Within the provisions of the West Bengal Highways Act 1964, clause 1(10)(1)(c), this notice is being served to you for removal of unauthorized portion of the structure from the said plot of land. You are therefore requested to kindly remove your unauthorized structure within your, with all your properties from the highway land within 30th October 2021, failing which the department will be compelled to take the next course of action.
That is a T5. Case 20.
So after the 10-1 notice at page 21, would the department have issued page 23 notice?
My lord.
A final eviction notice, what does that mean? Where is the provision?
Millard, may I just, Millard, for a second, may I take this sentence? I'm sorry, Millard, I have one copy and I also do not get it outside.
64 একটা আমাদের বোধহয় ইয়েতে আছে এইরকম কোন একটা আছে
10-2 টা দেখো না।
Yeah, 10.
10-2 টা দেখো।
Yeah. Millard, kindly see, 10(1) is removal of encroachment. 10(1) is, your lordship has seen that. Then Millard, 10(2) says that if the encroachment is not removed within the time specified in the notice, the highway authority or the officer authorized under subsection 1 may make an application to an executive magistrate having jurisdiction over the area, not being the district magistrate, for removal of encroachment and delivery of possession of the land encroach upon the highway authority or such other officer.
That was not done.
No, my lord.
No, that Millard, your lordship may kindly consider that there was an adjudication by the authority. Now, Millard, it has to be complied with in terms of section 10(2). Yes,
It's a
yes, yes.
preliminary adjudication.
Yes.
On the basis of which a 10-1 notice was issued.
Yes,
Since
yes.
that was not complied with by the petitioner, they ought to have taken recourse to 10-2, 10-3.
Yes, yes.
That has not been done.
Yes.
Instead, they have issued another notice, calling it to be a final eviction notice, which is not in accordance with it.
Yes.
The notice at page 21 is final.
Now, Millard, your lordship may kindly consider that there is a remedy of the petitioner in terms of section 10(3). 10(4), I'm sorry, Millard, I'm sorry.
10-3, the petitioner has
10(3) has to be complied with by the state.
has not taken recourse to 10 at all.
Yes.
They have issued a notice which is purportedly illegal.
Millard, I submit to my lords, Millard, in the event, your lordship is of the view that the provisions has not been, your lordship may kindly direct the authorities to complete the adjudication, but that cannot be a means, because why this writ petition is made pending? This is made pending in order to evade the particular, Millard, statutory provisions of the law. Therefore, Millard, it cannot act as a lever in favor of the petitioners that not to comply with the direction. That, Millard, your lordship may do. If your lordship is of the opinion that, Millard, I am handing over the book for my lord's kind consideration.
I have got the.
Yes. Oh, I'm sorry, Millard. I am sorry.
My lord, me kindly direct the authority to complete the procedure and me kindly fix a time frame.
Yes, that's all. Yes, yes.
My lord, we don't have any problem.
Yes.
Within 2 months.
My lord, as your lordship wish.
কি হচ্ছে ওখানে কি একদম সব শেষ করে দিয়েছি উঠে গেছি
Paragraph. The primary purpose of the
সত্যিকারের যত
petitioner is that
তোর এটাই তো ইয়ে বন্ধু দিয়েছিল তাই এটা হয়ে গেল
after service of notice upon the petitioners under section 10(1) of the West Bengal Highways Act 1964, alleging unauthorized construction made by the petitioners by encroaching upon PWD land, comma, the concerned authority has issued a further notice on 8th April 2022 threatening to remove the allegedly unauthorized construction from the plot in question within a particular time frame. Stop. No proceeding under Section 10 of the 1964 Act was initiated, proceeded with. The authority has not taken any steps under Section 10(2) or 10(3) of the Act. Paragraph.
এখানে এক্সিকিউটিভ ম্যাজিস্ট্রেট করতে হবে ঠিক আছে
Learned counsels for the respondents submits that the concerned authority, being the assistant engineer, the third respondent herein, be directed to conclude the proceedings under Section 10 of the 1964 Act in accordance with law. I'll fix a time frame. Paragraph: in view of the above, this court is inclined to hold that since proceeding under Section 10 has been initiated upon service of notice under Section 10(1) upon the petitioners on 14th September 2021, the third respondent be directed to take the proceeding to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, in accordance with law. This folder, not necessary. I have actually not gone into it. It's only a direction. There is no interpretation at all. Within 2 months, yes. Since one part is over already. Next.
Developers.
Lordship. In this matter, Lordship, the affidavit service is not ready because it is
not ready.
22 matter, Lordship. The service upon the private respondent are.
So please come back then after service. Since service is not complete, let the matter stand over till 17th April. 17th April.
17th. And for the state Lordship, they are appearing, Lordship.
Please serve another question. Next.
23 Lordship, I am praying not today on behalf of Mr. Parthopatin Royals. This Lordship regarding the calculation of the Lordship amount award granted by the competent authority, Lordship.
Let me fix a date.
27.
Yes. 27. 27.
As the earlier matter fixed on the.
But I am appearing.
17th Lordship.
State, Mr. De. On prayer of the petitioner, the matter is adjourned. Paragraph: let the matter appear under the same heading on 17th.
17th April, my lord.
Yeah.
Next.
The application is mine for being added as a party, my lord. This is my lord. The writ petition is challenging an order of demolition, although in view of encroachments on a highway, my lord. It was on my complaint that this was done, but I have not been made a party to this petition, my lord.
Appearing for the petitioner.
Petitioner, my lord, one Dijodas Chakraborty was appearing, my lord, and they rarely appear. This is called and they never appear, almost never appear. Either they don't appear or appear and ask for an adjournment. My lord will kindly see the orders. No effective hearing has taken.
State has also not been served.
State has, the problem is,
I'll give one date as a last chance, then I'll dismiss it.
my lord will kindly record an order.
Truncated week, so I prefer not to dismiss it today. Let's
But,
come on another date, I'll come.
my lord will kindly add me as a party. That will not prejudice anybody, my lord.
Come back. In absence of any of the parties, I cannot do that.
My lord will kindly record.
None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the, as a last chance, the matter is adjourned. Let the matter appear under the same heading on 11th April.
But may it be fairly at the top, my lord. That
It will appear, let us see. Next.
My lord, I beg to appear for the petitioner in this matter, ma'am.
On prayer of the Union of India, the matter is adjourned. Paragraph, let the matter appear under the same heading on 25th April.
My lord, I've been served upon a report by the Union of India, my lord. My lord, even though it is not required to, I do not intend to file an exception because the prayer is very innocuous that my land has been acquired for the purpose of construction of railway. They have started giving compensation from the year 2012. Unfortunately, I could not appear at that point of time. That is what they have stated in that there has been a lapse of 12 years.
So you don't need to come back with an exception.
No, my lord, that is.
Come back next date, let us.
My lord. Well, it will retain its. It will retain its.
Feel normal.
Okay.
Next.
After the petition, the report was asked for, my lord, by the order dated 4th of October 2023, my lord, and thereafter, my lord, December 5, 2023.
Not may I find the report in the form.
Have
And
you
my lord-
served a copy?
No.
No.
Sir, copies at least earlier.
26th. No, I'm extremely sorry, Lord. I'm
I
extremely,
need to,
He doesn't need to see the report. It is a report.
I'm extremely sorry for this one.
my lord, let me peruse and if
Yes.
and my lord, there is an interim order.
Order can't help. A report in the form of affidavit submitted on behalf of the fifth respondent is taken on record. Paragraph, copy of the report is made over to learned counsel for the petitioner in court this day. Paragraph, on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on
December Avon.
24th April. Paragraph, the interim order granted earlier is extended till 30th April 2024 or until further orders, whichever is.
Liberty to file exception if required.
ওর আগে একটা লাইন করুন on prayer of the ওই রিপোর্টে যেখানে মেড ওভার বললাম ওখানে on prayer of the petitioner liberty is granted to use an exception to the report if required.
No, I'm extremely sorry for being delayed in service. I'm extremely sorry.
We miss a date, isn't it? Next.
27 I'm for the petition.
Respondents.
Understood, madam.
There is a allegation of my lord the excavation of soil and my lord sold the same my lord to the brick mill owners. My lord, there is a only representation. My lord, that is not taken into consideration. My lord, that is at my page my lord 14. My lord, my objection regarding.
Have you served the private
My lord,
respondents?
every service my lord, no copy is my lord with me, my lord, that
Served, yes, there's a recording. It's recorded in the earlier order.
only direction, my lord, so that, my lord, the
Time dispute, my lord.
no, my lord, the allegation is, my lord, the excavation of soil and, my lord, sold the, kindly have a look on the second paragraph. Is it private dispute, my lord, the unauthorized extraction of soil and, my lord, selling the same, my lord, to the, my lord, the where is the permission, my lord? Why states not taken any steps saying?
It's a dispute between the parties.
The private respondents are excavating earth from your land.
My joint property, my lord, it's a joint property.
There is a public element.
My lord, the public element on the soil, my lord, the unauthorized extraction of soil, my lord, the
From government land.
no, it's not private land. Even the private lands, no one can, my lord, extract the soil, my lord, without taking permission. Without taking, my lord, there is a statutory provision, my lord, without taking the permission from the competent authority.
Is the writ court the authority?
Yes, my lord, when the, my lord, the statutory authority, my lord, is not taking, my lord, steps, my lord, for, my lord, extraction of soil, unauthorized extraction of soil, and, my lord, the removing the same, my lord, from the land.
This is under the Land Reforms Act, right?
Yes, my lord, there is, my lord, specified act, my lord,
Then
even then, my lord, the
writ court cannot consider, sir. I can grant you liberty to approach the appropriate forum.
all right, my lord,
Yes. This court cannot consider.
yes, my lord, say it's 4C, my lord, yes, my lord.
Conversion, yes.
Yes, my lord. Like, how was
The writ petitioners seek to withdraw the writ petition and approach the appropriate forum for redressal of their grievance. Paragraph in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Paragraph, there shall however be no redress costs as is certified by such. Next.
Lordship, I am appearing for the petition.
Yes.
Well, the petitioner come before your Lordship with a prayer for demarcation of his land unacquired. But the total land is 1 acre 42 decimals, out of which 95 decimals had been acquired and 47 decimals had been left out. Well, the petitioner made a representation before the authority, page 71, your Lordship kindly see. Application praying for demarcation of the land according to section 4 of notification issued in the year 95-96 in respect of the land lying at Mauja Tegoria, jail number 9, arrest dag number 139. But the respondent number 2 and 3 through their learned advocate filed a report showing the demarcation plan. Your Lordship kindly have a look at page 21 of the report.
Yes.
Well, the green color is unacquired, and unacquired part is at the two part, and middle portion is the acquired portion.
So there is already a demarcation.
Your Lordship kindly have a look at page 69 of the writ petition. At the second paragraph, in that Mauja, in another plot of land, the petitioner come before your Lordship and your Lordship pass this order. Collector not directed to cause a clear physical demarcation of the land, indicating the exact portion acquired as well as the unacquired portion belonging to the petitioners in order to enable the petitioners to raise a boundary wall segregating their portions from the acquired portion. Well, see, only for that reason, but in the demarcation plan, the collector shown only this part is acquired and that part is unacquired. Well, the petitioner is the owner of 4 kathas 8 chitakar lot out of 47 decimals. It is difficult on the part of the petitioner to go and construct boundary wall. But is the exact portion only that reason the petitioner come before your lordship.
Your Lordship, I am appearing for WB Hitco, the respondent here. I'm being led by Mr. Abrutosh Mojumdar. He has some personal difficulty today. Can it be taken up on Monday?
Hitco has no role.
They are the requiring body. They are utilizing the land.
They have utilized the land.
This demarcation does not show the exact.
My lord, it has already, my lord, he is the subsequent purchaser.
Maybe he can.
My lord, that is not the correct statement, my lord. Earlier one, Kasinath Mlaik moved a repetition before this honorable court. And pursuant
Relate
the
to his
court-
part.
Arre?
That is related to his part.
Both the matter is pursuant to the honorable court's order, my lord, it has been demarcated. They are satisfied. He has constructed boundary. Thereafter, he sold out the property to the petitioner and he has purchased the property. Now he is not in the position to take possession.
No.
Now he is coming before this honorable court. It is, my lord, and it is, my lord, annexed with this writ petition. What is the number?
Page your lordship kindly see.
Yes, 66.
66 and 67, your lordship kindly see. What was the demarcation made?
Same set plot number 139. And it has been alienated 2016.
Who was the writ petitioner? In
There,
that case.
in that it is
Another
Kasinath
person,
Mlaik,
another person.
from whom, my lord, the petitioner purchased.
He was also the co-sharer of the land.
So it has once been demarcated. You cannot ask for a second demarcation.
But I am the another person. I have the co-owner of the property. One person
The
come here and
dispute between you
the
and the
common demarcation was made by the collector. Your lordships have seen in the
Since the dispute is
plan
better and
placed in the report.
This is not a common.
And the
demarcation.
order your lordship passed.
The
in the
acquired portion has been demarcated. That is what is required, right?
That
That portion has been demarcated.
his portion not demarcated.
Acquired
Well,
portion.
in the your lordship kindly appreciate in the plan shown that this part is acquired and that part is
No, no,
well,
I'm
that
not,
part the
I'm
part
not talking about the present report at all.
your
Page
lord
66 says that the acquired portion in plot number 139 has been demarcated.
that is common demarcation, my lord.
What do you
No,
mean?
no, I am
common? There
difficult.
is nothing called common demarcation. Demarcation is a demarcation.
Demarcation, my lord, the land is 1 acre 42 decimals, out of which 95 acquired. That was shown in the demarcation plan, and
But
47
95 has
unacquired. That was shown. But I do not know where is
That
my land.
95 has been demarcated. If that is demarcated, you cannot ask for a further demarcation, a fresh demarcation. The authority will demarcate the acquired portion of the land, right? Not the unacquired portion. So if the acquired portion has already been demarcated in terms of an earlier order of this court, you cannot ask for a fresh
Your
demarcation.
lordship kindly have consider your
please come
lordship's
back to
order.
us, because
Your,
the-
your
That is
lordship's
another
order
thing.
page 71. Your lordship directed to demarcate the exact portions of the petitioner's land. So he is able to construct
Earlier
the
order
boundary
doesn't
wall.
say so. Please come back because the hit was
It's the identical matter. Your lordship kindly appreciate.
It is necessary, but Mr. Mujumdar will come.
prima facie. I do not find that you have a case. Please consider and come back. On prayer of the
সোমবার থাকবে হ্যাঁ
third and fourth respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 11th April.
বলো
11.
Next.
নামের এটা থ্যাংক ইউ হ্যাঁ
Lord, I am for the petitioner. Your lordship heard out the matter on several occasions, and your lordship was pleased to direct my learned friend to file a report in the form of affidavit on the. I don't know whether it has been now.
Did you go through this and come back?
My lord, my learned friend has relied upon a notification. But in terms of this notification, the state has preferred a appeal before the division bench. The Honorable Division Bench presided over by Honorable Chief Justice ex-Justice SUVRA Mukherjee is to hold that since in the lease deed there is no restrictive clause to pay the transfer permission fees, the state cannot demand. Against that, the state preferred an SLP before the Honorable Supreme Court. Supreme Court also dismissed the appeal of the Honorable Supreme Court.
Have you
Now,
annexed these documents?
no, my lord, just now I have got this copy. I can come with that SLP and also the division bench of this Honorable Court. Kindly fix a short date
Please annex the relevant documents
in my
in your exception.
exception.
Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph: on prayer of the petitioner, liberty is granted to use an exception to the report. Paragraph: let the matter appear under the same heading on 22nd April.
Well, kindly 22nd, prior to that, any date, but there is
19th.
17th, 18th, and 19th onwards, I shall be busy with the opener of my.
After?
After 10th, 11th. Well, after 25th, then?
26th.
26th.
26th April.
My lord, I am the petitioner.
Yes.
Led by the Mr. Tanmay Mukherjee is out of station. Kindly adjourn of the day.
My lord, my affidavit has been filed, my lord. Kindly.
On prayer of the petitioner, the matter is adjourned. Paragraph: let the matter appear under the same heading on 30th April.
30th April.
Grateful, my lord.
Your Lordship, I am appearing for added defendant. And Your Lordship, I am praying for a not today, my lord, because I am led by Anirudh Chatterjee and he's out of town.
You are the petitioner?
Yes.
Formally, I am for the state respondent in this matter. I have already filed my report. Another application has been filed by.
Added defendant wants time.
My only thing, my lord,
Occasional time happened.
my only thing, if the petitioner can be granted a liberty to give a supplementary affidavit, but to incorporate some documents which are not there in the writ petition.
I'll grant you liberty.
Yes, my lord, and we have filed a new Wakalatnama, my lord. I'm giving the number.
That will be in the department.
I've done it.
Wakalatnama in the
We have done it. We have to provide the number of that.
On prayer of the petitioner,
Petitioner.
liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph: learned counsel for the added respondents seeks accommodation. Paragraph: let the matter appear under the same heading on 26th April. Next.
This matter will.
I'm ready.
26th April.
26. Bhai, वगैरह supplementary दियो.
Please serve advance copies.
We will.
My lord, I am for the petitioner, my lord. I am praying for not today. My Mr. Sandal is appearing in this matter. My lord, he is personal difficulties. He is not present.
Prayer of
Only making not today.
On prayer of the not today, not possible. On prayer of the petitioner, the matter is adjourned. Paragraph: let the matter appear under the same heading on
First week of April, my lord.
4th April.
4th April, my lord.
Yes, 33. I am for the petitioner, my lord. The land acquisition case.
Respondents.
Article 300.
Mr. Bandyopadhyay is appearing for the respondent.
Yes.
And Mr. Bhattoba.
And that.
Have you served copy of the writ petition?
Yes, my lord, I have served 14 November 2022.
affidavit of
January 2024, there was a direction for service.
yes,
Have
my
you
lord,
served?
that service is a hardship. No, I have not found that further the copy will be served.
24th January, there was an order.
Yes, my lord, my lord. Even
Have
in
you
the
complied with
appellate
the
side rules or CPC.
Have you challenged this order before the Honorable Division
No,
Bench?
no.
So you have two options, either to challenge or to comply with the order.
But
Which
that
option have you chosen, sir?
I have not served. My lord, there is a law that dispense
Option
with.
have you chosen, sir?
Dispense
An
with.
order has been passed by this court on 4th January.
That it is
For
a,
service of copy.
yes, it is
You
a
have
law
to-
that further service of copy is dispensed with.
Have you challenged this order before?
No, my lord, no,
So if you have not challenged, you have to comply with the order. Have you done that?
no, no, my lord.
So you have to do either of the two?
Yes, my
If
lord.
you find this order is adheres the law, you have to challenge the order.
I have not challenged.
If you have not challenged, you have to comply
It
with
is
the
a
order.
minor procedural that in the land acquisition case, the minor procedural
sir.
will not come in the way of relief.
Do not
Or
make
the
all these irrelevant submissions before this court.
not in the
order
event.
was passed.
I can produce the Supreme Court case law.
Have you complied with the order or have you challenged the order?
As your lordship do that. I
You do not have a third route, sir.
No,
You
my
have to either comply or
lord.
challenge.
Yes, my lord, but I have not found any law in the CPC or appellate side rules.
No,
Rather, it has been dispensed with.
Will you
Further
please
service.
not waste the time of this court? There are several
I'm
matters pending.
I'm not killing time, but as your lordship can do.
It appears that the order passed on 4th January 2024 has not been complied with by the petitioners. Paragraph, the petitioners are directed to comply with the said order forthwith. Paragraph, let the matter appear under the same heading on 25th April 2024. Next.
Lordship order dated 9th of January 2022. You are directed to file report in a form of an affidavit in the matter.
Yes, Mr. Hamilton. Service.
Well, আপনি আছেন?
But I will go through it. If any exception to the report is required, I shall file.
I'll grant you liberty.
I shall file an affidavit. Then I shall make my submission.
Report in the form of affidavit submitted on behalf of the National Highways Authority of India is taken on record. Paragraph, on prayer of the petitioners, liberty is granted to use an exception to the report, comma, if required. Paragraph, let the matter appear under the same heading on 23rd April.
Yes,
23rd April.
23rd April.
Please serve advance copies or we again miss a day.
Lordship.
Next.
জনাব,
But this matter may be taken up on 11th.
Yes.
This matter may be taken up on 11th April.
11th April, all matters will not
The
be
earlier
possible.
matter is my matter. You have lordship directed to take.
11th
up
April?
lordship.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 11th April. 11th April. 2020. Next.
Lord, I appear for the petitioner, my lord.
Respondents.
My lord, I have
Sir?
received, my lord, it has been served, my lord. There was a direction to file a report, my lord. I have received the report. I am relying on their report only, my lord.
Who is appearing? Mr. Mahato and Mr. Supratim Dhar.
Yes. My lord, the issue, my lord, that my property was requisitioned under the West Bengal Premises Requisition and Control of Temporary Provision Act, my lord. There was under the Act, Section 10B, after 25 years, my lord, it is liable to be, my lord, de-requisition. Now, my lord, it was requisitioned in 1973. So, up to 1997, my lord, it ought to have been released. Milord, the actual possession was given in 2021. Now, Milord, I have a claim of Milord means profit and Milord the rent. Milord, in the report, Milord, they say they have not taken any steps. Certain amount has been paid, but they have not taken any steps on the basis of a understanding that I don't have any claim. And they also say, Milord, in the event, Milord, they have the power to, Milord, arbitrate. What I am today seeking, Milord, let the matter go before the arbitrator as per the report, Milord.
Do not
Milord,
find,
that is their, that is, Milord, the paragraph 23
shall
of
I
the
make it
report.
only not today? Will you inform Mr. Dhar and come?
My lord, that I do. I was relying on their report at page paragraph.
I understand, but today I do not find them.
My lord, then only kindly remain in the list, my lord, as it is today, my lord, I shall inform.
So shall I make it not today? Shall I give you a short date?
My lord, kindly make it not today, my lord, because it's running for some
Very
time,
well,
because I don't have very much to say.
It's a short matter. Can I dispose of it? Short, not today. Next.
The statement.
Petitioner 37, my lord, Kamlesh Shah is appearing on behalf of the petitioner. I am paying for only lot today, my lord. It could not come to the court.
You've taken several adjournments.
I have no brief, my lord.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 22nd April.
27.
Your lordship, I am appearing for respondents.
In this matter, Mr. Parthaputim Rai is appearing for the petitioner, my lord. He is on legs in courtroom number 4, my lord. I am praying for one-day accommodation, my lord.
My lord, I am for respondents too.
From record, my lord, I filed, my lord, that we have filed exception, my lord, that has been filed by the respondent number 226, my lord.
9th April.
9th April, my lord. Grateful, my lord.
Grateful, lordship.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th April 2024.
Gratefully.
Lord, I appear for the petitioner. If your lordship kindly takes the trouble to turn to page 16, annexure P3. But the project officer on periodical inspection reported that there was unauthorized occupation by the petitioner before your lordship on a ground.
A report was sought to be filed by
Now, some development has occurred. Madam, if your lordship will kindly permit me to hand over a letter.
My lord, my only prayer, lordship, can I give a not today, my lord, because I have just missed the brief, my lord. I think, my lord, my report has been prepared, my lord. Only
If your lordship kindly takes up, there is no need to adjourn the matter. But if your lordship kindly sees the last name, Muhammad Asanul Haq, he is the petitioner before your lordship.
Yes.
Now, the ADM LR Murshidabad has been addressed by the project officer. Request him that hearing was, if your lordship kindly takes up the last paragraph, page 5. Hearing was held today on 2024. The petitioners have intimated that they have vacated the acquisition land for which payment was made to them by Land Acquisition Department, and there is some quantum of land balance for which notice was served to them. Now, if your lordship will kindly sees that in view of the above, it is requested to arrange a joint survey on the suitable date to demarcate the questionable land under court case.
Yes, so
now, if it is done, then right at this moment, the petitioner possibly might not have any grievance to ventilate before your lordship.
Yes.
That is why I am praying that your lordship can pass an order basing on this memo and grant a liberty to the petitioner to approach before this honorable court if situation so arises. Thereafter, after the...
That liberty is not necessary, sir. The law gives you the liberty, isn't it?
But I am
If
very
you are
much
not
apprehensive. I am very much apprehensive the respondents before your lordship will come up and say that it has been disposed for
that
once
liberty
for all.
is always
And
there, my lord. That liberty is always there.
if the
very well, I will do that.
if the respondents do not make any allegation thereafter, I won't be able to make anything. আমার কাছে আর কপি নেই।
Copy of
ঠিক আছে ঠিক আছে ঠিক আছে ঠিক আছে।
a letter issued by the project director, National Highways Authority of India, to the additional district magistrate within bracket land acquisition, Murshidabad, and competent authority under the National Highways Act 1956 on 20th February 2024, produced by the petitioner, demonstrates that the petitioner, along with others, were heard by the authority on the said date. Stop. The relevant portion of the letter is required to be set out. 5 or 6. 5 hearing was held today, থেকে 6 as per court order. দাগ দিয়ে দিলাম, হ্যাঁ? Paragraph, in view of the above, comma, nothing further remains to be adjudicated in the present writ petition, and the same is accordingly disposed of. Stop. However, the petitioner is at liberty to take necessary steps for redressal of his grievance if situation so arises.
Much obliged.
Yes.
My lord, in this matter, my lord, I think my lord, my report has been prepared, lordship. Somehow, lordship, missed the brief, lordship. May I permitted to file the report, lordship? Though, lordship, the matter in this matter.
So this day you can.
My lord, I'm grateful to you, lord.
Not beyond.
My lord, my lord.
In that event, a copy may be handed.
Yes, yes,
Yes, একটা রিপোর্ট ফাইল করেন উনি, তাহলে ওটা একদম শুরুতে করে নেবেন। রিপোর্ট in the form of affidavit, in the form of affidavit,
in the form of affidavit,
submitted on behalf of the NHA is taken on record. রিপোর্টটা পেলে এই লাইনটা অ্যাড করবেন কিন্তু এটা হোল্ড করুন।
হ্যাঁ হ্যাঁ হ্যাঁ।
অর্ডারটা হোল্ড within 1 hour.
My lord, I will, my lord.
Disposed of কথাটা বলে দিয়েছি, শুধু urgent certified হচ্ছে। Next.
My lord, appearing for the petitioner, my lord.
Please wait, let me call the matter.
Lord, appearing for the petitioner, my lord, the advocate on record could not make it to court due to some difficulty. I have been instructed to seek an adjournment for not today.
Appearing for the response, Mr. Dev. On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 25th April. 25th April.
25th.
Much obliged.
Then I am for the petitioner.
To appear on behalf of the state respondent. My lord, your lordship kindly takes my lord our report in the form of an eviction.
My lord, the exception to the report has been.
Have you served a copy?
My lord, I have served. Lord, 6th of February. It has been served. The petitioner claims that the land which has been acquired for a particular scheme, my lord, and an agreement had been signed on that is annexure P2 of the page 22 of my writ petition, my lord, wherein it was specifically stated that one person from the family will be given an employment. From then, my lord, from 2001, he is going on fighting for the same, and he has been regretted without any proper specific reason, which I have stated in my exception to the report.
The agreement?
My lord, the agreement at page 22, annexure P2. Yes. Sufal Chandra Ghosh is the grandfather of the petitioner. The land belongs to, my lord, the father also. My lord, it has been given by the grandfather to the father, and then, my lord, it has been acquired. And the document has been annexed in my exception to the report. So, well, they have taken, in the report, they have stated that the land does not belong to me.
The land was acquired or donated by you?
My lord, it was acquired. And the second thing, what they have stated, that also, my lord, I have said that yes, I have received by an amount as compensation. That was, my lord, a meager amount. That was 7,000 of something of that sort in the year 2001, which was much lesser than the value of the government. Now, my lord, why I have accepted that compensation, that amount? Because, my lord, there was a clause that one person in the family will be given the employment. Now, my lord, what they have stated in their report, that the land does not belong to me or my father.
Page 4, para sub
But in the exception to the report, my lord, I have stated
Exception to
that, my lord, a proceeding under section 145 of the CRPC had been taken up. And, my lord, the revenue inspector has made an inspection, and, my lord, the report has been submitted. That I have annexed at page 16 of my exception, my lord.
Yes.
So, my lord, in the report, it has been stated also that same thing, that the land belonged, my lord, and the land, my lord, the copy of the deed, my lord, I have annexed there just after that report, my lord. Land belonged to my father. And I prayed for, my lord, that letter of regrets.
Chandra Ghosh again. এই দেখ না প্রসেনজিৎ ঘোষ son of কাঞ্চন ঘোষ তারপরের কথায় দেখ না 31 and উপশ্রী পার্থিব সুফল চন্দ্র ঘোষ
My lord, at annexure P6, page 40, that is the regression letter, my lord. Wherein they have only stated that there is no such scope. Why there is no such scope?
Page
That is
14 of the
40. Page 40, annexure P6, writ petition, my lord.
There was an earlier writ petition.
Yes, my lord. There, my lord, the order of consideration has been passed.
Order of consideration.
Yes.
It is being utilized by the PHE department.
Yes, my lord, PHE department. There is a water supply scheme, I think, my lord, that has been done.
Let us hear the response.
Yes, lord.
Lord, your lordship kindly takes page 4, paragraph Roman 4 of my report in the form of an affidavit. So that previously, my lord, writ petition has been filed, consideration order was passed, thereafter, my lord, contempt application filed, that has been dismissed. Thereafter, my lord, in pursuance to the order of this honorable court, my lord, kindly takes paragraph Roman 4, my lord, may I please? In any event, without prejudice, it is stated that the petitioner or his father is not the owner of the land where the public health engineering department set up its water tank, in as much as it was found during physical verification that the said water tank was constructed in the land of one Kalipada Sarkar, son of such and such, in plot number such and such.
How do you substantiate this statement of yours? You cannot just go to a land and find an owner.
my lord, after my lord verification, my lord inquiry,
The verification I would like to see. Have you seen title deed? Have you seen any document?
my lord, my lord, your lordship,
Because the petition has
yes,
two
my lord,
documents.
kindly takes page 7 of my report.
Yes,
দেখেন।
yes, page 7.
Lord, your lordship kindly takes, my lord, কালীপদ সরকার, দখলকারীর বিবরণের নাম। আর খতিয়ান number 364. This is the document I have relied upon. And I am relying upon this document, my lord.
Website that number.
And my lord, in the bottom, my lord, dag number 1088. Has your lordship got it? At the bottom, মোট দাগের সংখ্যা, just above, my lord. Dag number 1088. খতিয়ান number 364. নাম কালীপদ সরকার।
Which page, Dada?
7.
আপনি আপনার একরকম আমার একরকম।
কি বলবো?
আপনি কোথায় যাচ্ছেন?
The petitioner is Procedural GHOSH.
Yes, 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 yes. তাকে পদ্মশ্রী দিতে হবে,
চিন্তা
পদ্মশ্রী দিতে হবে।
নাম কোনো আছে তো?
খতিয়ান নাম্বার
The pump is in 1088.
Yes. দাগ নাম্বার 1088, নাম কালীপদ সরকার, বিরাট খতিয়ান নাম্বার 364।
That has been changed afterwards.
Yes, how do you substantiate? This doesn't tally with your documents.
My lord, the document I have produced there.
This name is in the record of it.
Yes.
The deed I have produced, my lord.
I guess petitioner.
Maybe that this was, this has not been recorded. Because
Because
my lord, it happens that
Either
when the land
petitioner's
has
name
been
nor
taken
his
up-
father's name below recorded in the record of rights.
That is the reason PPA was given. Compensation was given to Kalpatsa.
That's why below compensation amount was.
I have,
How do you show your possession?
my lord, I have shown
There
my
are
position
several
by the
correspondences also between the authority and the petitioner's
Yes.
predecessor.
predecessor
You have
also.
agreed to grant employment.
Lordship,
Yeah.
my lord.
But my lord, we would go by the records, my lord. After verification, my lord, this is the record of rights.
The agreement was entered into without going through the without going by the records.
My lord,
The land did not belong
Page
to.
22 of the writ petition.
yes.
This is by the PHE department.
Yes.
Yes, my lord.
The Bobby. One.
The agreement.
Page 16 of the exception.
Mhm.
This is a report of the revenue officer. This is
Lord-
your document.
Lordship. Lordship.
It needs.
কোথায় আমাকে দিস
But the land did not belong, a part of the land belongs to Akhil Kumar Sarkar, the other part is of Kalipada Sarkar. But they are showing of the Kalipada Sarkar, I have purchased it from, this deed is there. The deed shows that it is from Akhil Kumar Sarkar, my lord, Kanchan Kumar Ghosh, Pulab Kumar Ghosh, my lord, Pita Sukal Chandra Ghosh. That was the deed, my lord. My lord may find the Toporshili Chohudi, my lord. You will find, your lordship will find, my lord, Sulu Shatok Dag number Act 1088. Ostrashi Shatok Jumi.
Is it only crowd now?
Mr. Mitra, will you please go through this and come back
Lordship.
with necessary instructions? So these are your documents that
Lordship.
support the petitioner's case.
Lordship.
Lordship.
Absolutely. Yes.
Let them come back with further
Lordship.
instructions.
The big floor.
Third learned counsels for the parties. Paragraph, let the matter appear under the same heading on
My lord, a date may be fixed so that it can
সেটা-
appear, my lord, because last date also, my lord, you have fixed, but I am coming up to your lordship on
19th April.
19th April, my lord.
Lordship, my lord. As your lordship pleases.
I'll just go through once, my lord.
19th April. লিখে রাখো আর ওকে ডাকো।
Lordship. 90.
কাকে রাখবো? তুই আমাকে এক্সেপশনটা দিয়ে রাখ।
May it please your lordship, may I pay for the petitioner?
Respondents.
I am representing respondent number 2.
And one,
One, my lord, we have again served notice yesterday.
1 and 6.
But my lord, according to me, the main respondent is respondent number 224, Airport Authority.
Served 1 and 6.
This is.
My lord,
Okay. Uni.
Union of India.
Union of India was appearing virtually yesterday, I think.
Very essential party
Yes, where is he?
because decision will be taken by them.
But then kindly stay the notices, because I have to deliver possession by 31st.
Where is the notice?
Now, my lord, this is a long history, my lord. But my lord, final notices are, my lord, pages 180 and 186. But the school is running, my lord, under the orders of this honorable court. But may I take your lordship, my lord, through some of the facts? Now, but this is a school, my lord, which is running from 1953, September 1953. My lord, on a land of the then National Airport Authority of India. Thereafter, my lord, it required that, my lord, for the new terminal building, Calcutta Airport Terminal building, not the present one, the previous new one, the one which we have seen during our childhood days. Thereafter, my lord, another construction came up, which has again been abandoned, and now, my lord, the new one. Now, the one which is abandoned, my lord, constructions were to come out of, up over there, and my lord, the school was situated on that place. Therefore, my lord, the Airport Authority of India, my lord, issued a demolition notice to the school. Challenging that, my lord, a writ petition was filed before this honorable court. My lord, several orders were passed by this honorable court, my lord, in that writ petition, like providing for alternative accommodation, my lord, issuance of sanction plan, and my lord, direction to, my lord, issue, my lord, this land on leasehold basis to the school, where constructions would be made of the school building by the airport authority. My lord, we have a right to exclusive user. My lord, the orders of this honorable court has to be made part of the lease, and the school will, my lord, run on a rental basis of ₹1, so long the school runs. My lord, these are, my lord, some of, my lord, the salient features of the orders, my lord, which were passed by this honorable court.
Was initially a license granted to the school.
Now I'm having a lease, which has expired in 2021, 30 years lease. Now, what is very important is, if your lordship may kindly have a look at page 48, one of the orders of the coordinate bench of this honorable court. Now, these have all attained finality, my lord, subject to correction by my learned friend, my lord. No appeal was preferred, and my lord, these have been acted upon. Now, please take one of the orders, my lord, at page 48.
Yes.
Please take the third line, where these are all true copies, my lord. A school in the name and style of Calcutta so-and-so was being run at the Calcutta airport on the land belonging to the International Airport Authority of India. In or about 1972, the formation of the authority, the land on which the school was being run was transferred to the authority by the Civil Aviation Department, along with other properties which were transferred to the authority. The building of the aforesaid school is in a dilapidated condition and has been included under the alignment of the new terminal building proposed to be constructed by the authority, and therefore the school building needs to be demolished and relocated. A decision was therefore taken by the authority for the purpose of shifting the school to an alternative site near the airport hotel at Calcutta Airport, pursuant to the direction of this court in this proceeding as contained in the order dated September 23rd. The Secretary, Ministry of Civil Aviation, has approved an alternative site where the new building would be constructed. This is the first one, alternative site provided. Pursuant to the said decision, the authority has now allotted a piece of land measuring so-and-so on lease for 30 years on the basis of a token license fee of ₹1. per annum to run the school for the purpose of admission and education, mainly to the children of the employees belonging to the authority and other national agencies operating in Calcutta Airport. In view of the facts and circumstances above and to avoid any further difficulties in the administration and running of the school at the new site, the following order is made. The first condition is that the land so allotted shall vest in the International Airport Authority of India, but the school building, this is very important, school building will be constructed thereon shall belong to the school. The second important is, so long the school shall be run, the school shall pay a rent of ₹1 per month to the authority, and the school shall be entitled to exclusive possession, use, possession, and enjoyment of the land and the building to be constructed thereon. This second direction is very important for me. ₹1, so long the school runs. The school is still running. The school shall not alienate, encumber, sell, dispose of the building. If the school for any reason is permanently closed, then the school shall be made over to the International Airport Authority. The authority shall construct the building in terms of the plan as agreed by the parties and approved by this court. So plan was also approved by this court. In the approved plan, the elevation of the curved bit, your lordship may skip over that. Now kindly after 3 or 4 lines, the formal lease agreement shall be executed by and between the school and the International Airport Authority of India within 2 months after the managing committee of the school is constructed. In terms of this order, the authority shall commence construction, etc. Then the next is very important. The managing committee of the school shall consist inter alia of the following persons. 1 representative not below the rank of the director, deputy director, each of the International Airport Authority, National Airport Authority, and Indian Airlines. The International Airport Authority will be represented by the Airport Director, National Airport Authority by the Regional Director, and the Indian Airlines will be represented by the senior officer at least of the rank of Deputy General Manager. 3 elected representatives of the teaching staff, 1 elected representative of the staff of the Group 4 staff, 4 elected representative of the guardians, 1 person interested in education to be nominated by the governing body of the school, 1 nominee of the government of West Bengal, head of the institution, and such other members as the governing body would include, subject to the approval of the competent authority. The principal shall act as the secretary of the managing committee. Therefore, the fourth aspect is the managing committee, my lord, is constituted by the court, where, my lord, the airport authority is having an important role or is part of the managing committee. The existing management payment of electricity, etc., I don't trouble your lordship with that. Now kindly take, my lord, the next order, which my lord will find at page 54. My lord, I don't trouble your lordship with all the orders. The ones which are important for me, my lord, I'm sorry. My lord, at page 54, my lord, about 6 lines from the top, after hearing. After hearing the learned advocates appearing for the parties, the following order is made. All orders which have been passed in this proceeding from time to time, including the order passed today, will be specifically mentioned in the recital of the lease deed. In the recital, reference shall be made of the report dated so-and-so of the Secretary of such and such, which was submitted in this court, and the copy of the report shall be annexed as part of the deed. The Director of Airworthiness, Civil Aviation, so-and-so, will be the confirming party on behalf of the President of India to the lease deed to be executed in terms of the orders passed by this court. Srimati Malati Roy, etc., will execute. A clause should be included in the lease deed to the effect that the lease lessee shall be entitled to exclusive use, possession, and enjoyment of the land and building constructed on the demised premises. Clause number so-and-so shall be substituted by maintenance of the demised premises shall be borne by the lessee. My lord, I don't trouble your lordship with the rest of that order, except, my lord, at page 55, about, my lord, 7-8 lines from the bottom, where the sentence starting with the order passed earlier. Regarding representation of the Indian Airlines in the managing committee, the school is modified to the extent that either the regional director or any other officer duly nominated by him, not below the rank of so-and-so, shall represent the Indian Airlines in the managing committee of the school. The rest is the same. Therefore, my lord, these are, my lord, the binding nature of the order, my lord, where, my lord, certain rights, my lord, has been created in our favor, and, my lord, we are occupying that land, my lord, pursuant to these orders. The school is running, where the building has been constructed, lease deed has been executed. Now, my lord, the lease deed your lordship would find at page 61. I'll just take your lordship through, my lord, one or two paragraphs of that lease deed.
Yes.
My lord, my lord, we have given a typed copy, but it's better, my lord, your lordship may kindly have a look to this photocopy. My lord, please take me at page 65.
Yes.
My lord, mm, my lord, 6 lines, my lord, from the top.
Yes.
My lord, I'm reading from the middle of a sentence. Any other appropriate writ or writs, directives of the orders, and that the said application was admitted by the honorable court by such and such civil order number, etc. of 1987, dated such and such. So, but this has been, my lord, put as, my lord, part of the recital. Now, my lord, skipping over a few pages, please now come to, my lord, page number 70. Well, please take the 11th line from the top. Well, authority has allotted, my lord, a middle of a sentence. Authority has allotted a piece of land measuring about 4058 square meters on lease for 30 years on the basis of a token license fee to run the school for the purpose of admission and education, mainly to the children of the employees of the so-and-so authority of so-and-so and civil aviation and such. The honorable court made further orders that the land so allotted shall vest in the International Airport Authority of India, and the school building being constructed thereon shall belong to the school, and the school be entitled, entitled to the exclusive use, possession, enjoyment of the land and building on payment of ₹1 per month to the authority, so long as the school shall be run, and that the authority shall construct the school building in terms of such and such plan. Then, my lord, skipping over a few pages now, my lord, if your lordship may kindly take, my lord, page number 81. Well, I'm sorry, my lord, I'm troubling your lordship, my lord, with this copy. Page 80, I'm sorry. Page 80, my lord. But 11th line from the top, but there is a I within brackets, 11th line. The said land and the building shall be deemed to be a public premises as defined in the Public Premises Eviction of Unauthorized Occupants Act 1971, notwithstanding the lessee has constructed any further structure on the said land building. In the event the school building is taken over by under the so-and-so act, the respondent shall provide to the lessor alternative, equivalent, and convenient accommodation to the school near the airport at the cost of the respondents, that is the lessor. So in the event, my lord, they take over, my lord, they'll give me equivalent pay. Now please take, my lord, page number 81. Please take the 9th line, where there's a small f within brackets. The lessee shall be entitled to remove any materials, installation, equipments brought by the lessee in the demise premises within 30 days from the date of expiry of the lease, unless extended, provided that the lessee, if the lessee fails to remove any materials, installations, equipments from the demise premises, the same shall become the property of, etc. Then, my lord, the next clauses are, my lord, on the expiry of the lease, my lord, my obligation to, my lord, vacate the premises. But these are, my lord, some of the important, my lord, paragraphs, my lord, which.
Did you apply for extension?
Yes, that is, my lord, page 158. Now, kindly see, my lord, how, my lord, it has been, they have reacted to this. Page 158, 19/1/2021. This to inform you that 30 years lease of our school premises expires on 2nd of March. There is no managing committee at the school at present due to the case pending in the High Court, so we are unable to provide a copy of the resolution. I earnestly appeal to you, taking into consideration the future students of staff, to extend the term of the lease. Now, what is their response? Kindly see about the next page. Second paragraph. Your office, read a above quoted letter, requested this office for renewal of the lease extension for the said land parcel. In this regard, please find attached here with a copy of the format for request for allotment renewal of the land lease, and the same may please be got filled and returned to this office for processing the issue. They give us a format to process. The format we fill up, which is at page 160, and we submit it before the authorities. Then what they do is, they seek for certain documents which your lordship would find at page 166. I'm sorry, 164. I'm sorry. Yes. The case for renewal of the Calcutta Airport School has been forwarded to AAI CHQ. It is requested to provide the following details at the earliest: school status, whether the school is government funded or not, fee structure, whether any outsourcing is done, whether AAI is a stakeholder, any quota, etc., copy of the award agreement, etc. Your reply with please reply with documents as attachments immediately. We reply the next email on the same page. Yes. Towards the end, dear madam, with reference to your email dated so and so, I am furnishing the details of the school required by you. We forward it. Then kindly have a look to page 166. No, it was the Aki, sorry. No, it's the same document. Yes. Then your lordship may kindly have a look to page number 173. In the meantime, they ask for the balance license fee. We pay it. I don't trouble you with that, Now kindly take page 173. Yes. They ask for the audited accounts and all that. But this is on 8th of December, 22. Please refer to your letter of so and so. During scrutiny of the documents received by this office, it is found that the following documents have not been submitted: copy of ITR for the last 3 financial years, copy of the audited accounts, etc. Now, thereafter, your lordship would find, my no, the next page is page 174, 22nd December. This has reference to the various emails and subsequent meetings held with the committee members and representative of the airport English High School for renewal of the lease of school land. The duly constituted committee of the airport director so and so is of the opinion that the standard prevailing land rate for the school is calculated amounting to rupees 3 crore 22 lakhs and odd. That is rupees 8010 into 4024.96 square meter plus GST. It is requested to submit your willingness or otherwise for payment of rupees 3.22 crores.
So from rupee 1 to 3 crores.
From rupee 1 to 3 crores. Yes. But I have skipped over one page. Please come back to page 169. I'm sorry, Milord.
Yes, 169.
Milord, here they say, this has reference to your letter regarding the above mentioned subject matter. The renewal of the lease of the school at rupees 1 per month is not agreed by the competent authority. The so-and-so school has to pay the normal license fee. Then, Milord, the 2 other pages I'll trouble your lordship with is page 100 and
decided by the court.
By the court, fixed by the court. Then they call for me for a meeting, and finally, please take pages 180 and 186. Please take the second paragraph at page 180, where this is 23rd of March 2023. Second paragraph, the subject lease deed was executed on 26th November 91 for a period of 30 years commencing from so and so on a token rent of ₹1 per month only. On the expiry of the lease, it was requested by the lessee to extend the term of the lease for 30 years or more. Vide letter dated 9/7/21. The said request has been examined by the authority but not acceded to, as the authority is of the view that the purpose of capacity enhancement and to optimize the use of available land for aviation purpose, which includes proposed extension of operation area, and also considering the fact that there is already constraint of land, it would not be possible for the authority to accept the request for extension of lease. Further, under the provisions of the lease deed, lessee is entitled to remove the materials, etc., etc. Next paragraph, therefore, I call upon you to quit vacate, deliver quiet and peaceful possession of the demised premises on or before 31st of March. And where the last document, my lord, which is relevant, is page 186. Once again, my lord, in the third paragraph at page 186, my lord, they asked me to vacate. Now, my lord,
Yes.
now, my lord, in the backdrop of, my lord, the various orders, my lord, which have been passed by this honorable court, which have, my lord, the parts of which, my lord, I have placed before your lordship, my lord, the rights which have been conferred to these orders plus the lease deed, against which, my lord, there had been no appeal, and which have attained finality, and the parties have, my lord, acted upon. My lord, the rights which have been conferred to me is, number one, that I have a right to occupy at a fee of ₹1 per month so long the school runs. Undisputedly, my lord, the school is running, and we intend to carry on running of this school. Number one. Number two is, my lord, in terms of the court's order, my lord, I have got, my lord, exclusive possession of the school, or the possessory right, my lord, has been conferred upon to me. My lord, number three is, my lord, the respondents, my lord, they are supposed to, my lord, be a part of the managing committee. My lord, factually, my lord, I am told, my lord, from a particular point of time, my lord, they are not participating in it. Number four is, my lord, the school building, my lord, belongs to me. Number five is, in case they require it, then it is to be treated as a public premises, and, my lord, they are going to, my lord, provide me alternative accommodation with, my lord, whatever is there. Therefore, my lord, today, my lord, a prayer for extension, my lord, your lordships have held. What is the difference between extension and renewal of lease? Extension is only expanding the time. Renewal, of course, is a fresh grant. Now, we don't find that, my lord, from their various documents that there is any decision not to extend. The decision is, my lord, contrary to the court's order, that why only ₹1, it should be 3.22 crores. Which again, my lord, is contrary to the court's order.
They have not really turned down the prayer for extension. They've only said that they required the premise.
Right, right. But that is my case. The extension.
Not be possible for the authority to accept the
Yes.
request for extension.
Right.
They've turned it down.
Yes.
They've turned down the prayer.
Turned down on the not on the ground of any other requirement. These are all, my lord, subsequent things, my lord, which have crept in. Your lordship will find, my lord, in response to my first application for extension, they are not bringing in all these issues. They say that you apply in a prescribed format. My lord, I apply in the prescribed format. Then they call for documents saying that for processing your application, I need this, that, etc. Those were provided, my lord, in 2 trenches. Then, my lord, they may take a decision saying that no, we can't extend unless you pay this. Even today, my lord, there is no decision or resolution that they are not going to extend. Now, my lord, let us assume for argument's sake, my lord, there is some decision which has not been communicated to me. Maybe these are in their files. Then also, my lord, these cannot be, this kind of a decision cannot be taken, my lord, in the backdrop of the orders of this honorable court. Number, I'll address your lordship on 2 basic issues. First is, my lord, as to the tenability of these order, this decision, my lord, in the backdrop of the court's order. And number two, Millard, today, Millard, since Millard, we are at the interlocutory stage, Millard, what is the scope of Millard passing an interim order, or to what extent, Millard, your Lordship can protect me? Now, Millard, so far as the first point is concerned, Millard, your Lordships have held, Millard, that so far as, Millard, any decision which is taken, Millard, contrary to the orders of the court, they are nullity. Therefore, Millard, kindly permit me to, Millard, place this decision before your Lordship. There are a number of decisions. I'll just rely on one. 2013, volume 16, Supreme Court cases, page 147. But relying upon various decisions, Millard, kindly take note only one paragraph, paragraph 46.
Yes.
Placing reliance upon the earlier judgments in so and so, so and so, so and so, this court in Manohar Lal versus Ugrosen held that any order passed by any authority in spite of knowledge of order of the court is of no consequence, as it remains a nullity, and any subsequent action thereof would also be a nullity. Well, whatever rights have been conferred on me by the court's order, Millard, gets nullified by, Millard, the last two annexures, Millard, which I have placed before my Lord. Therefore, Millard, these orders are nullity, and, Millard, subsequent actions which are whatever they contemplate are also nullity. But this is in respect of, Millard, my first submission, which of course, Millard, your Lordship would be dealing, Millard, at the time of final hearing of the matter. Now the question is, Millard, of the interim order. Millard, interim orders, Millard, I would be, Millard, today, Millard, seeking stay of these bunch of notices rather, on the ground that, Millard, today, Millard, what the protection that I require is the protection not to be dispossessed. Because by 31st, Millard, I am supposed to, Millard, vacate. Whatever is the merit of the orders, Millard, your Lordship would be, Millard, deciding at the end of it. But today, Millard, if it is not stayed, Millard, I have an obligation to vacate. And if I don't vacate, then also, Millard, they cannot throw me out, Millard, overnight. But on those, Millard, there are, Millard, line of decisions, Millard, one or two, Millard, I'll cite, which says that even if somebody is in unauthorized possession, he has to be removed through the due process of law, and it includes the state also. It includes, Millard, kindly note down the citations, Millard, in a previous matter, Millard, I had the occasion to place these judgments before my Lord, Millard, in that Port Blair matter. 1989, volume 4, Supreme Court cases, page 131, paragraph 8. Thank you. Paragraph 8 only.
Yes.
Mr. Tarkunde, learned counsel for the defendant number 3, the appellant herein rightly did not go into the appreciation of evidence either by the trial court or by the High Court or the factual conclusions drawn by them. It was, however, strongly urged by him that the period of license had expired long back and the plaintiff was not entitled to renewal of the license. It was submitted by him that in view of the license having come to an end, the plaintiff had no right to remain in charge of the business or the premises where it was conducted, and all that the plaintiff could ask for was damages for unlawful dispossession, even on the footing of the facts as founded by the High Court. We find ourselves totally unable to accept the submission of Mr. Tarkunde. It is well settled law in this country that where a person is in settled possession of property, even on the assumption that he had no right to remain on the property, he cannot be dispossessed by the owner of the property except by recourse to law. If any authority were needed for that proposition, we could refer to the decision of the division bench of this court in so and so. This court in that judgment cited with approval the well-known passage from the leading Privy Council case of Midnapur Zamindari, where it has been observed, in India, persons are not permitted to take forcible possession. They must obtain such possession as they are entitled to sue the court. With the next judgment, two judgments are of our High Court. The first one is of 2003 SCC Online SC. I'm sorry, 2003 SCC Online CAL 379.
Yes, paragraph.
Paragraphs 13, 14, 15, 16, and 19. 13, 14, 15, 16, Millard, these are Millard, Mr. Mukherjee's submissions noted, Millard, based on various Supreme Court judgments. Kindly take Millard the conclusion at para 19.
Yes.
In the affidavit, it has not been explained whether the aforesaid situation after all existed before demolition. But this is the case where demolition had taken place. As such, the contention of Mr. Ghosh is such a fallacious that does not deserve any merit at all. Accordingly, the same is rejected. I hold with the agreement of Mr. Mukherjee's contention that this wanton act of demolition and destruction of the structure of the premises is only unauthorized, malafide, and arbitrary. As far as destruction of materials are concerned, there is no justification in putting forward. Therefore, this is wholly high-handed action and sheer abuse of power. Then we kindly take note what is the final relief granted. Though, Millard, I am not at that stage, but still only to protect my rights. Please take paragraph 23 and 24. Millard, paragraph 23, the last three lines. I direct the respondents to restore possession of the premises at the demolition at the demolished site. The petitioner will be entitled to put up further structure. I appoint so-and-so advocate as special officer to ascertain and further quantify the damages suffered because of this illegal unauthorized destruction and damage to the property of the petitioners. He shall come to the fact finding, considering, etc. But this is for the purpose of awarding damages. But the last judgment, these judgments are only to prevent, what should I say, the further affectation of rights. Kindly take the last one, 2017 SCC Online Calcutta 9473. But this is a division bench judgment delivered by Justice Bhattacharya. Well, kindly look at the clause, Millard, quoted at paragraph 7. Clause number 15.
Yes.
Clause 15, HRBC reserves the right to take back any area within 3 months, with 3 months notice and refund the sum already deposited for such areas for the balance period on pro rata basis. Simply pro rata will be applicable and no weightage of any other factor shall be considered. This was the right retained with the respondent over there. Then we'll kindly take paragraph 16. Again, Mr. Mukherjee's submission is noted that you cannot take possession otherwise than in the due process of law. And finally, kindly take note para 29 and 37. We're noting that clause number 15, but this is the finding of the division bench.
Yes.
If we apply the principles laid down by the Honorable Supreme Court in those cases, in the present case, we find that the defendant cannot take back the possession of these allotted site from the plaintiff forcibly and without taking due course of law during the subsistence of the contractual period, notwithstanding reservation of the right of taking back possession from the plaintiff in clause 15 of the contract. Plaintiff is no doubt in settled possession of the allotted sites as the plaintiff was given the right to display advertisement, etc. I don't trouble you with those. Now kindly take me finally para 37.
Yes.
Under the circumstances, we set aside the impugned order by holding that the plaintiff has succeeded in making out a strong prima facie case in favor of grant of temporary injunction in his favor and the balance of convenience, inconvenience, and also in favor of grant of injunction. Accordingly, we allow this appeal and pass an interim order of injunction restraining the defendants from disturbing the possession of the plaintiff in the suit till the disposal of the suit, otherwise than in due process of law. I am seeking for this injunction at this stage as as per para 37 of this judgment.
That's all.
These are my-
My lord, various facts have been brought by the learned counsel, Mr. Dotto. Most of the facts are admitted. I am not disputed. But some relevant facts which have not been represented properly. First, I bring to your lordship's kind attention that Airports Authority of India has been set up under the provision of the Airports Authority of India Act 1994. It is a central government organization and statutory organization. This authority has been set up for the functions air-related air traffic service incidental thing. My lord, the matter related running of school. What was the background of that school? That school is a private entity, not government school. They are making profit by taking high charges. My lord, I am coming to the point. What was the background to give land long ago, that is in the year 1970 or 71? It is true that some land was given by the then International Airports Authority of India. Airports Authority of India is now successor of that International Airports Authority of India. At that time, in the locality, there is no sufficient standard school to educate the wards of airport authorities employees who were residing at that area. Because many employees are coming on transfer from different parts of India. Under that background, for running a school, it is true, some lands was allotted.
These facts were considered by the coordinate bench while
Yes, my lord, I am coming. All these things I will be coming. My lord, kindly give me short time. I will not linger my submission. Only I am giving this background. And that time school land was allotted and it is acquired land. Under the Airports Authority Act, airport land cannot be used for any other purpose other than functions as made under Section 12 of the Airports Authority of India. That is aeronautical service, other service. School, however, for public interest, lease may be granted, lease for public interest, showing for under the terms and conditions. And that lease grant power vested with the central government, Civil Aviation Ministry, not with Airports Authority of India. Accordingly, temporarily, at that time, lease was granted, and in order of the Honorable Court is very clear. It is for 30 years. If we go through the order very carefully, we find that there is no provision after 30 years what will happen. Even there is no extension clause. Extension clause is not there. However, I may admit, for the sake of argument, that one provision is there, if not extended. That clause is there. So therefore, at best we can say there may be implied condition, it may be extended. If it is extended, then it is okay. Fresh terms and conditions to be agreed. That has not been made. In the earlier order, there was no mention. After 30 years, what will happen? My lord, all the orders have been covered under the lease. And now lease deed is final. We have to go by the lease deed. After entering into the lease deed, no party has challenged the same or disagreed the same.
I am sorry, I have to stop you at this moment because you'll take some time, I believe, isn't it? Let us continue on the next date.
Yes, that can be.
And the notices impugned will be stayed till the next date for the time being.
For the
Let us
time
continue.
being, no
Yes.
problem. Can it be fixed on Monday, my lord?
Monday, Sunday, Monday.
You come back on Monday, 1st April.
Unless I'm fooled on that day.
I was about to say so, unless it is. Heard learned counsel for the parties. Paragraph, paucity of time intervenes. Paragraph, since the court is in session of the matter, comma, the notices impugned dated 29th March 2023 and 10th November, the second notice. 10th
Please give me a
November
moment.
2023 be stayed till the adjourned date. Paragraph, let the matter appear under the same heading on 1st April 2024 at 12:30.
29th March and 10th November. These two have been stayed.
Yes.
I'm grateful. Wow, I have to.
So let it be second April.
But could it be next Friday, subject to lots next Friday?
Very well. That is 5th April. 5th করুন, adjourn date অবধি বলেছে আমি state. 5th April.